Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us as we are continuing our coverage of California versus Carlos Dominguez. The jury has been deliberating since last Friday, so over a week now. Granted, they did take Thursday off, and Friday was only like 15 minutes. So in reality, a week has been Monday, Tuesday, Wednesday. So 3 solid days. Only one time there was a jury question, and it was about line instruction of line 600, and it was about the. I'll replay it because we have, while we're waiting for jury, or while we are in jury watch, I'm going to go ahead and play a couple other things too. So it was about a plan. Is a plan required? Does it require preparation? So it was talked about a direct step, and it was specifically with Kimberlee. So to begin with, I want to replay closing arguments because I didn't really watch them, and Capri Law and Widespread Panic were taking notes. So I want to replay that because I wasn't really paying attention. So I want to replay that. But let's see, first of all, who is with us in our chat? Who's with us today? Who's joining us today? Shelby Allen is first in chat. Let me see if I can find you. Where's Shelby Adams? Let's see, Aaron had to connect to the chat. Okay, so I won't be able to pull that up, Shelby, but good to see you. Widespread Panic, fantastic. Thank you for joining us. Brett, Sherry M, Green-Eyed Cat, Golden Girl, hello to you. Irish Amy, good to see you. You missed the end of Donna. Did they rule? No, Irish Amy, he's going to issue a written response, a written rule. He does not rule. Well, in this case, he did not rule. Judge Everett did not rule from the bench. So that's going to be coming from in a written rule. Jade saying, how's Polly and the kittens? Jade, I'm going to play a little clip for you guys. Here, you know what? While I'm talking, why don't we do that? Why don't I do that? Let's see here. Let me get my camera going. And, yeah, here. Let me play some, while we're talking a little bit, we'll play some kitty action for you guys. There you go. So there's Polly. Kittens. All right, let's see, who else is with us? Let's see, Psychosaurus Rex, how are you? Good to see you. Alice Howell, thank you for joining us. Capri, nothing from Newton yet. I just texted him just saying what we're planning on doing. So texted him about 10 minutes ago, waiting to hear back from him. Ruby saying good afternoon. Hey, Mary Brown, good to see you. Brett, thank you for joining us. So kittens are doing fine. They were a week old yesterday, so they're 1 week and 1 day. Ahoy there, Drunky the Bear. How are you? And yep, Capri. Nothing from. Oh, here. Let me do this. Put that over there. Nothing from Newton. Waiting to hear back from him. Hey, Gordon. How are you? Good to see you. Thank you for joining us. All right, so I want to replay closing arguments because I missed them. So, Mary, let's see. Sorry about asking about Donna being live. I thought it was Saturday. Wondering why Saturday. Oh, I missed that. Yeah, no, this has been a weird week for me too. Like I missed recyclables are on Wednesday. I totally missed that. Thursday, I thought yesterday was Friday. Today, I'm like, oh, I get to sleep in. Yeah, nope, it's Friday. Got to get up. It's been a long week because we're doing dual streaming. We're doing Carlos, verdict watch. We're doing Lori, and then we're doing recaps. I mean, it was a long week. We did cram a lot in 1 week. So as you can see, everybody's doing good. Polly's tail is towards us. Her little head, you see, is way up there in the corner, the left corner. You see a little ginger there. See a little head's moving there. We got one closest to us, a little kitten closest to us. Hey, Deborah, how are you? Good to see you. Thank you so much for joining us. And please be sure to hit the like button as you guys are coming in. Psychosaurus, gosh, the kittens are getting so big. They grow up so fast, I know. Wendy, how are you? Are you sure the jury didn't run away? No, they had a jury question. They did have a jury question towards the end of the day on Wednesday. Oh, you had surgery too. Sorry to hear that. Wendy, they've been deliberating. They started last Friday. Now, granted, it was only 15 minutes, but they started last Friday. They went Monday, Tuesday, Wednesday, full days. They were off yesterday, Thursday, and then now they're back on today. What is the other trial about? In what regard? This trial? We have a lot in our description if you want to go check our description. Yeah, it is Friday. Slim and Ember, yep. Ember's back there. Slim and Ember are back there. All right, so I'm going to play the closing arguments because I missed them. So we're gonna leave our little kittens for the moment, and I'm going to go back to here, and we're going to play closing arguments from Friday. This was from last Friday, closing arguments from last Friday. So I want to check this out. So here we go.
I'd like the jury now to give Mr. Moore their full attention, and this is the people's closing argument. The jury is yours, sir.
Thank you, Your Honor. Good morning. April 26th, April 29th, May 1st, 2023. David Breaux, Karim Abou Najm, and Kimberlee Guillory were ambushed and stabbed. Stabbed in one of the most cold and calculated ways you can imagine. Senselessly, callously, brutally, with intention, with deliberation, and with premeditation. David Breaux, while sleeping on a park bench in Central Park, suffered 31 knife wounds from a combat knife, a hunting knife. Karim Abou Najm, 52 stab wounds from that same combat knife, that same hunting knife, as he rode his bike home from a conference in Sycamore Park. Kimberlee Guillory was slightly more fortunate because she lived, because her attack, her ambush was interrupted by friends who came to her aid and stopped the defendant from
Objection
accomplishing.
misstates testimony.
You can clarify. Proceed.
Stopped when Kimberlee screamed and people came out of their tents. And the attack stopped at that point. She suffered 2 wounds. One was so significant it required the highest level of trauma response to go to UCD Medical Center, with the highest level of trauma response at the hospital, in the second highest grade of trauma and severity that you can have, a level 4. All of these stabbings, all of these attacks, all of these ambushes were committed by one person, Carlos Dominguez. Mr. Dominguez, the defendant, was schizophrenic, is schizophrenic. But he's also lucid, able to premeditate, able to form intent, able to attack and stab and kill. That is what this case is about, ladies and gentlemen. That is what you have been here for the last several weeks, of hearing how Mr. Dominguez, despite his schizophrenia, despite his life events, developed an intense anger for these 3 truly innocent people. These individuals, as you have heard, through the evidence, through the witnesses, they did nothing. They didn't threaten Mr. Dominguez. They didn't have weapons. They simply existed and went about their lives until they were no longer able to. That is critically important in determining what happened on those days. They were targeted. David and Karim, in their last moments alive, were targeted. Kimberlee was targeted. Mr. Dominguez saw them, perceived them, approached them, stabbed them. Not once, not twice. In the instance of David, 31 times, Karim 52, and Kimberlee twice. 85 stab wounds with that combat knife over 3 victims. And how these transpired over the course of those 6 to 7 days, all at night, all in dark areas, all with victims who were perceived to be alone. Very few witnesses, very few people to come to their aid. No reason to suspect that there was a killer right in their vicinity. Ladies and gentlemen, this is what we call a pattern, an MO. Selecting your victims particular times of the night in areas where they're unsuspecting. A pattern. The defendant's actions were willful, deliberate, and premeditated. And they were personal. Why are they personal? Because a stabbing is one of the most personal and intimate ways to harm someone, to attack them, to kill them. It is not like shooting a gun where you can point from a distance and hit your victim and hit your target. No, it is anything but that. You have to get right in that person's face. You have to see them, perceive them, look at them. You have to feel their breath. You have to see their eyes. You have to deal with and listen to their screams. Oh my God, help me. You have to feel the knife slit through their shell. Almost like a poem. A metaphor? I don't think so. You have to feel their life leaving their body as you stab them over and over and over again for 31, for 52, and another 2 times respectively. Personal. You know what is happening in that moment. You also have to understand it's personal and people will struggle. A victim will struggle. And to attack someone in that manner, you have to be hell-bent on accomplishing what you set out to do, of overcoming a grown person's strength, a grown person's fear, and a grown person's fight for survival. The defendant overcame those things when he attacked David, when he attacked Karim. That, ladies and gentlemen, in those 2 instances, is murder. Proof beyond a reasonable doubt. And in Kimberlee's situation, while she's sitting in a tent, playing on an electronic device, on the ground, take 2 knife wounds down, that is attempted murder. proof beyond a reasonable doubt. Now, this case has some facts that are in dispute and some facts that are not in dispute as well. So, the issues that we are dealing with here, the issues that we are here to talk about, what is undisputed in this case? We'll have to prove it beyond reasonable doubt, but what is undisputed? The defendant stabbed David, and David died as a result of that stabbing. The defendant stabbed and killed Karim. The defendant stabbed Kimberlee. She lived. Those are not in dispute. The defendant used a knife, a deadly weapon. Not in dispute. The question before you, ladies and gentlemen, the issue to be decided in this case is what was the defendant thinking when he ambushed these three people, when he attacked these three unsuspecting people? That is the question to be decided, and what the facts and the evidence, both direct and circumstantial, will tell you that he knew what he was doing in those moments. There were a series of life events that led up to this moment, and that is why he did it. He thought about it, he considered the consequences, he acted anyway. And he did it with that intent to kill. So, as you have sat here for 5 weeks, you've heard from dozens of witnesses, lots of testimony. And let us summarize what we have heard to date. Now, we've heard about the defendant, Mr. Dominguez, and we've heard about his story. I want to focus on what we have heard when he went to college. Now, when he went to college and he got out of Cosmont High School and went to UC Davis, he didn't do so well. Actually, he did very poorly, as we know, because he was expelled from the university. But that academic performance brought along with it some other issues. Some other issues that maybe were part of Mr. Dominguez's personality to begin with. Anger, punching walls, punching doors, fighting roommates, smashing phones, getting upset when he believed people were talking about him, attacking random people to ride our apartments. Yeah, college is frustrating. College is hard. But when you see a series of events like this, where your reaction to failing tests is hitting a wall, when you punch a door, when you break a toilet, when you start shoving and fighting with your roommates, your fraternity brothers, you start to see this pattern. You start to see this pattern of a temper. Add to that the personal issues that Mr. Dominguez was having at the time. We heard from Kaylee Gardo, his ex-girlfriend. We heard from Mr. Dominguez himself about this. He loved her. She had loved him at one point. And Ms. Gardo also said that he was possessive. He was jealous. Mr. Dominguez didn't like her to be around his roommates. She eventually broke up with him. Now there's debate as to whether he took that well or not and got over it. But what we have heard is that he didn't actually get over it. He kept going back to her, trying to get together with her, make physical advances at her. Up to December of 2022, January of 2023, time frame is a bit hazy, even gives her lingerie, personal intimate items. She rejects his advances, tries to keep him from getting back together with her. And so he has all these issues that are starting to come to light. And when they broke up around April or May of 2022, he writes this poem, Knife in My Hand. The defendant says it's a metaphor, but when you look at it and compare it to all the other evidence we've heard, this is not a metaphor. This is a warning. This is almost like an intent of a future act that actually ended up coming true. And up till a week before the first stabbings, he's still trying to reach out to her, trying to get together. She shuts him down. And so he has these personal issues going on. He has these issues with his roommates as well, which we heard from his former roommates, Mark Capito, Phil Hahn. They've all given evidence about his temper, his anger, how he'd smash things, how he'd fight or get upset. And then we have the knife. On December 10th of 2022, we're no longer going and talking about poems, we're talking about actual physical knives. And Mr. Reales Dominguez, we know, everyone has an Amazon account. We know how Amazon works. You click in the search bar, you type in something, and you get like 5,000 different search results. He had 500 cached pictures of knives on his phone. Now, that is not to say if you looked at 500 knives, that's to show you how many options Amazon has to purchase knives. And what he searched for, what he bought, he looked for hunting knives and combat knives. Not pocket knives, not utility knives, not folding knives, not throwing knives, not carving knives, not kitchen knives, hunting and combat. And as a result of that, he got this. A sturdy, fixed blade, double-edged weapon. Now, this idea that this was for carving and throwing at trees, the defendant said he carved into one tree, in Sycamore Park. Ladies and gentlemen, that knife has been used 3 times as many times on people as it's been used on trees. David, Karim, and Kimberlee. It's not a carving knife. The only thing it did was carve deadly wounds into his victims. So, with that purchase, with that state of mind that we are starting to see develop with the defendant, we move to April 26th, April 27th of 2023. And what happened in Central Park in Davis at that time? Now, David Breaux is sitting there at night, picks a bench that is very far away from anything. He picks an isolated spot in Sycamore Park, in Central Park. There are no footpaths there. There are no walking paths. There are no sidewalks. There are no bike lanes. There's very little light there. Why? So he can sleep. So he can be undisturbed. And we saw Sergeant Diaz's body camera when she responded on April 27th, and she had to walk about 200 feet north to get to the sidewalk. That's how isolated it is. Because David wants to sleep. David wants to be left alone. And so He makes his bed. We saw the clothes that he had laid down on the bench, so there wouldn't be a draft that came up. We saw his backpack, likely used as a pillow at that time. And he has 4 layers of clothes on him, trying to sleep. And as Dr. Jew said, he was likely laying on the bench, back out. And his face was facing the back of the bench, where the slats are. And what we know is that David was approached by the defendant. The defendant has to perceive, has to see, has to know that David is there. And he has to form the intent to kill him. And we know he did because we find a knife sheath 2 to 3 feet away from where David is, as AMR paramedic Patricia Mendez said. Why does that matter? Why does that 2 to 3 feet matter where that knife sheath is? One, it's the first piece of evidence that links us to the defendant. Otherwise, pretty clean, pretty perfect crime scene. But what it also tells us is that the defendant had to walk up to David. He had to look at him, remove the knife from whatever pocket or sweatshirt he had it in, and he dropped it, or it fell. This is grass in the park and dirt. We know that on David's clothes. And he has to approach and begin attacking him, begin stabbing him in the back. Now, David had wounds to his back and his front. He had dirt on his chest and on his left leg and his shoes. So what do we draw from that? That David fought back. David fell off the bench and he turned and he faced his attacker. He faced the defendant at that time, and there was a struggle. Every time that knife went into David, he was trying to live. Even to the point where his hand is up and he takes a stab wound straight through his hand. And you can imagine, you can infer from that, based on the other 2 stabbings, that he was likely screaming and terrified. You can hear it, you can perceive it, you can feel it as well. Now, that knife sheath that I mentioned, that's not to prove identity. That knife sheath had Mr. Dominguez's DNA on it, had the defendant's DNA on it, and it matched the knife that he was found with on May 3rd of 2023. And that knife, jumping ahead to May of 2023, May 3rd of 2023, had DNA from other victims. Sweatshirt had DNA from other victims. So, let's move forward to April 29th of 2023. And what do we know about that? We mentioned Karim is riding back from a conference, 9:10, 9:15 in the evening at that point. He's going through Sycamore Park, going home. And we know, based on Dr. Massey's Nest Cam videos, that he's riding his bike into that park. Dr. Massey, remember, lives across the street. And Dr. Massey, he testified, heard within his backyard, and from across the park, he can hear these screams of, oh my God, help me. And the voice starts to trail off. The defendant has attacked Karim at this point. As Tiffany Hodgins said, that she's sitting in her house with her daughter, and hear commotion. And she's still in her house, going towards the back door, and she hears like someone is getting beat up. Multiple thuds to the chest. Now, she is not at the scene. She is obviously at her house, which backs up to the park. But the sound is so loud, she can hear this. It is so distinct, she knows there's an attack. And what we can infer from that evidence, from Dr. Massey and Ms. Hodgins, is that Karim was riding his bike, collided with the defendant, and falls off of it. We saw where Karim was at the time. He was off the bike path, and Dr. Massey runs over there, try to render aid. You see what happens? He sees two individuals there. Karim, who we now know to be the defendant. Now, Karim is off the bike. There's only one bike there. The defendant didn't have a bike there, so we know that this collision happened. Now, when we look at what the defendant testified to, and he said that he perceived what we know to be Karim coming through the park, and he stepped in front of him and caused a collision. As Dr. Massey approaches with a flashlight on his phone, the defendant gets up, hops on the bike, and flees. He says something to the effect of, "What do you want? Leave me alone, man," or "Leave me alone, what do you want, man?" But that man is critically important. That man is very important because it shows the defendant knows those are people. Those are people that he is coming into contact with, that he's seen, that he's attacked, and that he's fleeing from. Now, when you look at the witness testimony in this case, and you look at the credibility, and you give the instruction for witnesses under Calcrim 226, when you look at that, you will weigh what you believe, how you believe them, why you believe them. Dr. Massey, very meticulous, very methodical in his testimony. Thought it through. He even came up with his own report with timestamps. So that testimony of man is important to show what the defendant perceived, what he knew, what he intended, and how he premeditated. Hops on Karim's bike, flees. Ditches it across the freeway, across 113. Twice now, because he wasn't found at the scene for David Breaux, twice now we have flight. Twice now we have consciousness of guilt. He knew he did something bad, and he flees. Now, to mention, Karim, 52 wounds, 52 stab wounds. But where those stab wounds were is going to be very important because they were centered mostly in the heart.
Counsel, I need to stop you.
Okay.
If you display anything, I need it forewarning.
Oh.
Are there any graphic pictures?
There are none that are graphic. Any ones are covered with sheets.
They show, I issued an order that you would not live stream anything that depicted the deceased.
If I come across one, I'll warn the court.
Just give me a heads up.
Okay, thank you.
Thank you.
All right, I don't know if I hit one yet. If I did, I apologize to the court.
I don't know either.
Okay.
But thank you.
All right, thank you. And so, those wounds are centered in the heart, a vital organ. What has vital organs? People. Humans. Persons. And so, let's move to May 1st of 2023. At this point, we've had 2 murders. We've had 2 stabbings. And David's community is on edge. The unhoused population is on edge. They're worried. They're concerned. And so a group of unhoused people, led by Isaac Cheeseman, they gather together, protect themselves, and keep each other safe. They set up at 2nd and L, in a small encampment that's there. And we know that Kimberlee Guillory is one of the people who has been taken in with this group, and she's given a tent. And with this tent, she returns home late in the evening on May 1st, and she sits down on the north side of her tent, playing on an electronic device at this point. And so, as she sits in this tent, her neighbors just to the north of her are Christine Barrios and Isaac. And Isaac, person who has gone from state prison to now a machinist, housed, driving a car, has his very elaborate tent set up there, and hears a noise. Like a string is being cut on his tent. It alerts him. And shortly thereafter, he hears Kimberlee scream. Kimberlee's been stabbed. She thinks she's been punched twice, or multiple times. She stands up and there's blood, and we see that, or they see that, she's been stabbed. We know based on video surveillance that the defendant had ridden his bike through that area. He'd come up 3rd Street, likely came up H Street, and ended up in the area of 2nd and L. He stabs them, and video surveillance shows him leaving that area and taking not the most direct route home. Shane supposedly falls off his bike, he goes on the UC Davis campus, and picks an area, an alcove that's hidden off of the path to try to fix it. Flight 3 times. 2 days later, defendant's at Sycamore Park again. Justin Schaefer makes eye contact with him. They see each other, and as Justin said, at that point, I saw this guy, thought he was either the guy or a guy dressed as the guy. Defendant gets up, leaves. He ends up going to Safeway. And at Safeway, as Detective Mez said, looking at the surveillance video, he just looks like any other person there. You see the video, nothing that stands out about him. Shopping, picking up items, eventually steals them. He has no cash on him. He does have a knife. And as police contact the defendant, they stop him, they respond to the area, and they start talking to him. He gives a fake name. John Jonas or John Joas, he gives both. Gives his birthday to 10/10/99. Holding that bag. Holding that bag and clutching it. You can see in the video how hard he's holding that bag. It is not because the handles are missing. It's because there's a knife in there. There's a murder weapon in there. That bag is so uncomfortable to hold. Why not put it down? Why not put it under your arm? Hold it like this. Cradle it. No. He doesn't want anyone to see what's in there. But why is that false name so important? Because the defendant testified he had given that name before, and the police had let him go. So as he had hoped, he'd be let go again. State of mind. What's he thinking? And so, ladies and gentlemen, when we look through all of the facts of those, then he goes out at night. He carries a knife with him, a combat knife with him. We know he doesn't bring his cell phone with him. We know he didn't bring music with him to stop hearing the voices he claimed to have heard. And in each instant, he finds an unsuspecting victim who is at the receiving end of his premeditation, his anger, his intent to kill. a pattern. A pattern. So they acknowledged already, Mr. Dominguez has schizophrenia. We know that. That is not something that's being contested here. He has schizophrenia. He's shown a pattern of increased development of schizophrenia or increased symptoms over time. We know that based on his roommates. We know that based on Kaylee. He was diagnosed in a clinical setting by Dr. Patricia Tyler. He was diagnosed in forensic settings by Dr. Weiner, Dr. Benson, and Dr. Ree as well. So he has it. But in looking at his schizophrenia, you need to be very aware of this. You can be schizophrenic and you can still act consciously, form intent, commit crimes, and murder people with premeditation. It's not one or the other. It's not. You can be schizophrenic and not kill people. You can not have schizophrenia and kill people. They don't exist in isolation. And so be very, very aware of that when you're evaluating the testimony, the evidence in this case. And as we look at his diagnosis of schizophrenia in this case, and how it played into his mindset in this, how the hallucination, you have a jury instruction on hallucinations, you have a jury instruction on his mental state as well, mental disease or defect. You have those things. And so when you're evaluating what the experts, what the doctors looked at in coming to the conclusion that Mr. Dominguez was floridly psychotic during this time frame, the source, the biggest source of the evidence for that came from the defendant and how he described the events, how he described the murders. Now look at that and compare it to his testimony. Look at 226. Everything that the defendant gave us about those stabbings, everything he said was a lot of words, but not a lot of explanations. He remembers everything before, remembers everything afterwards. And everything in between was a I blocked out, so I don't know, or I don't remember. So if he was floridly psychotic and seeing hallucinations, was it just in those moments and he snapped out of it and he's fine? Evaluate the basis for that evidence and that opinion and look at the witness credibility and the factor of whether someone has a vested interest in the outcome of this case. Look at how someone answered the questions that were posed to him on cross-examination. And look at whether that is reasonable, that you not see and know and feel the blood and hear the screams of the people he stabbed. Mr. Dominguez, as we've seen, is able to function in society. Every morning he would get up. He would get dressed. He would go to the UC Davis campus at times. He would obviously charge his phone at times. He would power his phone off at times. He would make food. He would text his girlfriend. He would sign up on classes. Obviously, he can buy items on Amazon. He can function and do the things that you and I can do. Yes, while he is schizophrenic, he still is able to make those decisions. And so, don't think about them in isolation. Schizophrenia and the ability to form intent. Now, ladies and gentlemen, getting into applying the facts to the law in this case. Now, your duty is to apply those facts to the law. Okay? What facts they are, what are important, what's not. There's some things you heard in here that may not be super important to this case. Khalid Siddiqui, probably not important. Steve Ramos is probably not that important. What's important is the actions, the intent, the mindset, how Mr. Dominguez committed these crimes, and the why. And so you look at those facts, apply the facts to the law, and use your common sense when doing this, and reach that just verdict. Now, as we get ready to start applying the facts to the law, I am going to summarize a lot of the law. On the slide right here, I have violated a cardinal principle of PowerPoint and put too much text on it. So I admit to you that I did not do what I should have done and summarize it more. But I give you that warning because if I say something that is inconsistent with what His Honor instructed, or it says something a little bit different, you follow the law as given by His Honor. That is what you follow, right? Not the summary that I give. And so I bring this up because I've referenced it. You already instructed on it on 226. Looking at how witnesses answer questions, other facts to determine credibility. All witnesses start at the same level, even experts, even the defendant. And then you gauge their credibility, their believability, what you believe, if anything at all. And so, one of the things to think about is the vested outcome a witness may have in the case. We talked about that. Be aware of that. Consider that when you're evaluating testimony. Now, the law, you've been given the reasonable doubt instruction. Now, proof beyond a reasonable doubt is my burden of proof in this case. Proof that leaves you with an abiding conviction the charge is true. Something that every courtroom in this country, that is their standard proof. You don't speculate, you don't do things like that. So, when you are evaluating evidence, as I've mentioned, you can use your common sense. What makes sense? What is reasonable and what is not in determining just outcome and verdict in this case. Now, you've been instructed on first-degree murder, second-degree murder, attempted murder, and you've heard about this lesser of involuntary manslaughter. Now, normally we go through first crime, second crime, third crime, and we get to the lessers. I'm going to start with the lessers in this case because it's very easy to say the lesser doesn't apply. Right? The lesser crime of first-degree and second-degree murder of involuntary manslaughter requires criminal negligence. So think of criminal negligence as
objection asked approach, please.
Okay. All right, Mr. Moore, continue people's closing argument.
Thank you, Your Honor. Now, I was going to do it reverse. I'm actually going to reverse it and do it in reverse. How about that? So, also a trick to keep you awake. All right, so getting to murder. Now, you've been instructed on Calpern 520 and 521. So, we get into this idea of, or these legal concepts of what murder is. Now, murder is the killing of another person, or the death, killing of a person by another person. Easy. Simple concept. That's the foundation of homicide statutes. And now, to get to the murder statutes, first degree, second degree, it has to be killing of another person with malice aforethought. Now, malice aforethought, as instructed, is, there are two types. There's express and there's implied. Express is the intent to kill. Now, I'll go through murder of David and the murder of Karim, both separately and overlap as well, because the express intent to kill were the actions that the defendant took on those days. And so, with express malice, look at the number of times that they were stabbed. 31 and 52. And I know I keep bringing up those numbers, but it wasn't just a one and done and he moved on. With David, he made sure, the defendant made sure, to continue to stab and stab and stab. Over and over and over again. Overcoming his fight and his power. Karim 52 times as well. And as Dr. Massey said, the calls for help, the voice trailed off. That is that expressed intent to kill. And that's what we have here in those two charges, in count 1 and count 2, on April 26, 27, 2023, and April 29th of 2023 as well. That malice of forethought, intent to kill, express intent to kill. Now, express intent does not have to be like, I intend to kill you. It doesn't have to be that way. It's the actions itself that speak volumes, that tell you what his state of mind was at this time. So there is implied malice as well, where you take an act, or you do an act where the natural and probable consequences is going to end up being dangerous to your life and leading to death. Summarize that. But we're really looking at express in this case. So, the malice of forethought, as instructed by the court, does not require hatred or ill will towards the victims. Mr. Dominguez did not have to hate David. He did not have to hate Karim. That's not what is required. But it is formed before the act that causes death is committed. David's case, where that knife sheath is at the time, in the movements of removing that knife from the sheath and perceiving, seeing David, is enough to form that intent. Running into Karim, knocking him off of his bike. We know that if you collide with someone and you fall backwards, there is a space, there is a gap. That means there's distance. Distance that you have to close at that point. And so in the moment of closing that distance, malice forms. Because that knife, remember, no longer has a sheath on April 29th. And so it has to be carried in a way where the defendant's not going to cut himself. And so he has to take extra precaution to grab that, to carry that knife, to grab that knife, to close the distance, to mount Karim and start stabbing him. Malice, intent to kill. And so, that is what we know about how that malice is formed. Now, as I mentioned earlier, we can look at the vital organs that were struck, the defendant stabbed on Karim, in the heart region as well. We don't know the order in which those stab wounds occurred, but there's a large concentration. What's the fastest way to disable someone, kill someone? Go for the vital organs. Go for the head. Stab them through the lip, knock the tooth out. Multiple incisions on the head. Multiple concentrations of deep wounds in his heart. And as you're considering that evidence, as you're considering that intent to kill, one thing to consider as you're viewing the evidence, Dr. Abou Schmidt, the pathologist who did Karim's autopsy, when asked, when she testified, his clavicle was broken. How much force does it take to break a clavicle? She said a lot. Multiple ribs were broken as well. And for someone that we have heard substantial testimony about who was deteriorating in weight, that takes a lot of force and a lot of rage to do that. And a lot of commitment to make sure that Karim isn't able to get up, that he isn't able to fight back, that he isn't able to call for help. All goes to mental state. Now, the malice we talked about, defendant goes to, I'm going to step back and go to count one with David again. I told you they would overlap a little bit, similar facts, same knife. Defendant is armed at that time. David is unarmed. Approaches, removes that knife from the sheath, wounds the back and the front and the hand as well. So for David, for count one, premeditation. So malice starts at second degree, premeditation brings you up to first degree murder. Willful, deliberate, premeditated. The willful is that intent to kill. The premeditated is you think about, you stop and you think about, you weigh the considerations for and against doing this, and you know the consequences, and you still decide to go forward with what you're doing. And so that distance that I talked about is very important. The location where David is very important because it requires someone to approach, perceive, and make that decision. Remember, no walkway, no bike path, no sidewalk, no parking spaces. Isolated area of Central Park. So David just wants to sleep. And so the person approaching him, defendant, can assess that, has plenty of time to consider whether I should do this or not. Consequences of doing this or not. And the premeditation, the reflection that transpires and still doing it. Each one of those elements is met for first degree. Willful, deliberate, premeditated. Guilty, count one. Now, there is going to be a covered photo in the next slide round.
Okay, can we just pause the live stream for a second? Okay. Hold on just a second, sorry. How we doing? Audio, yes. Video, no. Thank you. Go ahead.
Right, I moved over that slide. After this one, there will be another one, Your Honor.
Okay, we're doing audio, no video.
Perfect, thank you. Right, now, going back to Karim. Same analysis. Defendant is armed, David is not. Karim is not. Vulnerable, unarmed, not making threats, trying to ride his bike home when this happens. Now, the location where Karim was murdered is, yes, it's a dark area of the park, but the bike path sweeps into that area. So where the defendant is, the defendant can see him and perceive him as well. Now, this is just based on physical evidence and inferences we can draw from that. It's not based on the defendant's testimony alone, because we can get there without it. And so, as Karim is riding this teal bicycle into the park and ends up colliding with him, and they knock each other back, the intent to kill is already there. In that moment of falling backwards, in the space between them, allows time to consider, to go over the consequences, disregard them, and to still act. There's enough time there to reflect on what has happened and not do what the defendant ended up doing. All important. And because of that,
here's what I found.
Because of that, he's guilty of count 2 as well. Now, with count 1 and counts 2, you have what are called special circumstances for multiple murders. And so if you convict for counts 1 count of first degree, or 1 count of second degree, or 2 counts of first degree, then you would find that multiple murders applies as well. And what the evidence shows you, as applied to the law, is that these are 2 first-degree murders. And the defendant is guilty of both. Now, with that physical evidence that we have seen, and if you want to add to that the defendant's testimony and the statements to the forensic doctors as well, is when he was talking, the defendant was talking about David's murder. He said voices he heard for the very first time, the whispers he heard for the very first time, and he said, "You're not going to go up to him." Him. Very specific. Defense says it's a shadow, but as we know, shadows don't have genders.
Which actually misstates evidence.
Overruled, you'll be allowed to argue.
And so he knows, and this was listed on cross-examination, refers to a male, refers to a person. So he perceives that person. And as we heard from Dr. Reed yesterday, in Karim's killing, as he's talking, the defendant is talking about this, he says he saw a dude. Now, that is important because there's a back and forth. Was he saying this knowing now that this was Karim? Was the defense saying this knowing now this is Karim? No. He's saying this based on what he perceived then. And what he perceived then was a dude, a person, as well. Because he's being asked to recall what had happened. Schizophrenia does not mean you don't understand. It doesn't mean you can't perceive and form intent and murder and premeditate. So moving to Ms. Guillory, Kimberlee Guillory, count 3. Attempted murder. Now, this takes...
Actually, let me stop you there. It's a nice place to stop. Okay, thank you, Mr. Jamara, and we'll give you time on the other side to finish up.
Thank you.
And ladies and gentlemen, the jury, thank you for your work this morning. We have a full afternoon. We'll meet you back at 1:30. Don't form any.
All right, hold. That's okay. So that's closing arguments are continuing with the state. So let me just get over here to our. They took their afternoon break. So let's get back on. All right. Sorry, I don't know if it was I guess I might have been muted. All right, so they broke for lunch and now they're back. Still no word. They're still deliberating. I've got eyes on like all kinds of. I got Newton hoping he texts me. I've got a couple feeds going. I'm on some websites. So hopefully we will find out when a verdict does come in.
Session today, this Friday, and we're in closing arguments, and we're on the people's closing argument. Mr. DeMar, we have everyone here, and the floor is yours.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Now, can I get the overhead? Perfect, thank you. Now, when we left off this morning, we were talking about how the defendant is guilty of first-degree murder for David, and first-degree murder for murdering Karim. Now, each of those charges carries with it an enhancement for personal use of a deadly weapon. That deadly weapon being the knife. We know the knife led to the death. It was used in murdering them. It was personally used by the defendant, so that should be easy finding on that. I'm not going to spend a whole lot of time on that. Actually, that's all the time I'm going to spend on that. So, there is a lesser included charge for murder, first degree and second degree. It's called involuntary manslaughter. And involuntary manslaughter, you only get to that if you return not guilty verdicts on first degree and second degree. And then you would consider this. You will not consider this because, or you will not have to fill out this verdict form because these acts were intentional. They were not criminally negligent. They were intentional. And so, based on the evidence and the proof beyond a reasonable doubt for counts 1 and counts 2, you will not, should not get to consider involuntary manslaughter. Now, that brings us to count 3. And count 3 is attempted murder of Kimberlee Guillory. Count 3 includes 2 enhancements, one for great bodily injury and that same personal use of a deadly weapon. Now, because Kimberlee is fortunately alive and with us today, that is why we only have the attempt. Now, the attempt has 2 elements that you must consider. The defendant took at least one direct but ineffective step towards killing another person. The defendant intended to kill that person. And the next slide will have a graphic image, if we could cut the live stream for that.
Just the, yeah. Okay, great. We still have audio. Okay, great.
Great, thank you. And so, when we're looking at this, that direct but ineffective step took place when Mr. Dominguez came down L Street, observed the tent where Ms. Guillory was sitting, got off the sidewalk. Remember, she's facing the north side of the tent, as indicated here in this photo from the body-worn camera. The opening to her tent is facing the retaining wall of the PG&E substation. And so that required the defendant to get off the sidewalk, walk, assess, approach, take his knife that he's still carrying without a sheath, that he still has to carry in some way that would allow him not to stab himself, not to cut himself, retrieve that, and what we know is that Ms. Guillory was stabbed down because that's where she was seated. Lower back and mid back. Twice. And so, that action is that direct but ineffective step. The ineffective portion of that is because it wasn't completed, because Ms. Guillory screamed, because Isaac Cheeseman and others heard this. They tried to rush out their tent, and there was a commotion about that. Now, there's also, with the attempted murder, there is also premeditation alleged with this. Premeditation is the same as we have looked at for the other charges, for counts 1 and counts 2. The intent to kill, a deliberation, and a premeditation. Having time to think about the considerations, the consequences, the ability to reflect on that. And that's what the defendant did as he walked up and perceived and thought and assessed and formed that intent to pull out the knife and stab her. Now, when the defendant testified, he said he punched, he made a motion like this. We know that motion is not accurate to what the physical evidence shows. But where those injuries were in Ms. Guillory, down her lower back, required crouching down. And that movement of dropping down and striking her with that knife is the time to reflect, additional time to reflect as well. Excuse me. Great bodily injury is an allegation attached to the attempted murder that the defendant personally inflicted great bodily injury. So this is a significant or a substantial injury. It's not like a cut or a laceration, things like that. Significant or substantial. And as we talked about this morning, this was one of the wounds, one that lacerated Ms. Guillory's kidney, was the significant and substantial wound. Based on the response it prompted from the trauma surgeons, from the ER surgeons, the level 5, her blood pressure was extremely low. She was in the ICU for 7 or 9 days. Substantial period of time. You heard from Dr. Schatz testify about that and the significance and his concern about this injury. And so we have this GBI is true as relates to Ms. Guillory. Now, ladies and gentlemen, that covers our charges in this case. That covers the proof beyond reasonable doubt for those. But there's other evidence to take into consideration when looking at guilt. And you were instructed on consciousness of guilt. Now, we talked about how the evidence shows that the defendant fled after he murdered David and after he murdered Karim as well. And we know that he fled when he stabbed and attempted to murder Kimberlee as well. And he got on his bike and he saw the surveillance videos taken back westbound through downtown Davis, and he rides a bike down 8th Street, and we get further, he cut through a parking lot, and eventually he lands on UC Davis's campus. And in the still shot of this surveillance video from UCD, we saw him go past the ATMs and go into this little alcove there that's hidden from public view to fix his bike chain. If your bike chain has fallen off, and has been off your bike for that long, there's substantial ways or substantial opportunities to fix it well in advance of finding an alcove hidden from view, or what you think is hidden from public view. Could have done it before you got to the alcove. Could have done it by the ATMs. Could have done it downtown. Could have done it around the corner from Ms. Guillory. So, we have consciousness of guilt, and that's something that you can consider and weigh. So, ladies and gentlemen, when you are considering the evidence, when you are rendering your verdict, take all of that into account. What makes sense and what is reasonable and what facts apply to the law. And you will find that the defendant is guilty. There is proof beyond a reasonable doubt in this case. Now, we've mentioned the defendant's story. And as we said, CalCrim 226 allows you to assess the credibility of witnesses. Remember, you assess the defendant's credibility the way you would any other witness. And so when you are assessing that story is neither reasonable nor sensible. Direct examination, he was very forthcoming with his answers, filled in details about his life, about his childhood, about college. But on cross-examination, there were a lot of I don't knows, and was surrounded incriminating acts that he's charged with. Each time he didn't remember, didn't know pertinent details, and assess that, whether he was answering the questions. So, when Dr. Weiner was testifying on cross-examination, when he's being asked questions about what do you do to control for the information that you are getting? How do you know someone is telling you the truth about what they are charged with, or the crimes that they're charged with? And he basically said, there isn't a test for that. I don't assess that. That's for the trier of fact. And he's right. The truth of those statements, the truth of those answers or non-answers is left up to you, ladies and gentlemen. And when you make that assessment, when you make that determination, you will find that this was not because Mr. Dominguez is schizophrenic. This was because Mr. Dominguez intended to kill and premeditated when he did that. He says he doesn't remember what happened on those dates related to the crimes, but you remember based on the evidence and based on the testimony. And ladies and gentlemen, when you weigh that, there's only one verdict you can reach. Guilty. Thank you.
Thank you, Mr. DeMora. That was the people's closing argument. And at this time, I'll invite Mr. Hutchinson to set up for the defense closing argument.
Good afternoon. As many witnesses told you, this was probably the most serious, the most high-profile case in recent Yolo County history. And it was a case that required serious adults. It was a case that required real adults. And I don't mean Hannah Cheney's definition of a real adult of someone over 30. It requires people who recognize the importance of this case, the seriousness of this case, the necessity of doing a thorough and competent job. People who recognize it is in the important cases where you cannot cheat, you cannot mislead, you have to play it straight. People who recognize the importance of following the law, even when it is difficult to do so. People realize that a serious case does not give you an excuse to lie. It does not give you an excuse to cheat. In my comments today, I am going to be extremely critical of the prosecution and law enforcement. And although I will refer to law enforcement by their names, when I refer to the prosecution, I will only refer to them as the prosecution or the prosecutor. I do that because I want to emphasize that my criticism is not directed at them as individuals. They are prosecutors selected by the elected district attorney of Yolo County to prosecute this case in the name of the people of the state of California. And my criticism is directed at their actions in their role as prosecutor, their arguments in their role as prosecutor, the questions they made as prosecutors. Ladies and gentlemen, this is a case that required serious real adults. And that you were given an investigation and a prosecution that can only be described as juvenile amateur hour. And I think juvenile is being a little too generous, because there are many high school mock trial teams who would be embarrassed to present the case, to give the arguments that this prosecution gave to you. What you saw in this investigation, what you saw in this prosecution was not normal. You recall when Ms. Rocha was on the stand testifying about Mr. Dominguez's appearance in July of 2023, where he was wearing a suicide smock. That was undisputed. Why did he even ask questions? Well, you saw an approach from the prosecution to, on cross-examination, not to try to elicit new information, just to ask the same questions that I asked, but try to say it in an argumentative way that made the evidence seem less damaging to them or not as significant. So he was asking Ms. Rocha, well, Mr. Dominguez's attire would have been normal given a particular defendant's circumstances. And Ms. Rocha looked at him and said, I don't think any circumstance in Mr. Dominguez's case is normal. And you saw that firsthand throughout this trial. You must base your decision solely on the evidence presented, your evaluation of the evidence, your common sense and experience, and these instructions. What attorneys say is not evidence. Nothing the attorney says is evidence. In their opening statements and closing arguments, attorneys discuss their case, but their remarks are not evidence. Their questions are not evidence. Do not assume something is true just because one of the attorneys suggests it was true. This is true even if the attorney says it over and over and over again. It still doesn't make it evidence. This is true even if the attorney says it in a dramatic voice. I can use a dramatic voice just as good as the next person. I can give a dramatic closing argument. But I think all of us have had enough fake drama for one day and enough fake drama for a trial. So what do we hear about the prosecution's arguments regarding specific intent and mental state? The prosecutor said Mr. Dominguez was just a lot of words but not a lot of explanations. I'm going to borrow that quote. There are a lot of words but not a lot of evidence. Just a number of stab wounds and a lot of words by a prosecutor that is wholly unsupported by the evidence. You know, they make a lot of statements about schizophrenia, but they did not ask that about the experts, nor did they get their own expert to explain that these statements they gave to you were true. You would think if this case was so clear, that the mental intent was so clear that it was obvious to a couple of untrained prosecutors with a few hours of Google research, surely they could bring in an expert to explain this to you.
Objection.
Yes, sustained. Yeah. Disregard the reference to Google.
Well, you can use your common sense and experience. But what attorneys say is not evidence. Where is the expert to explain to you all the points about schizophrenia that they're trying to make? You know, they argue people with schizophrenia can still form an intent to kill. And yes, that's common sense and experience. No one would argue otherwise. But did they ask any of the experts anything about a person with schizophrenia's ability to form an intent? No, they just decided to attack these experts' bias, their credibility, psychiatry as a whole. It was throwing everything at the wall and seeing if something would stick. Because they had nothing. Now, we begin with the presumption of innocence. A defendant in a criminal case is presumed innocent. And this presumption requires the prosecution to prove guilt beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that a charge is true. What does abiding mean? Enduring, lasting. You're not going to wake up next week, next month, or next year and wonder whether they really did prove intent to kill. Did they really prove conscious disregard for human life? Because based on the evidence, you know that is the only reasonable conclusion. And unless the evidence proves guilt beyond a reasonable doubt, a defendant is entitled to an acquittal, and you must find him not guilty. It's not optional, it's not discretionary, it's mandatory. You must find him not guilty. As I told you, the physical acts in this case are not in dispute. The question that is presented to you was, what was Carlos Dominguez's specific intent and mental state when he committed those physical acts? What was happening in his mind? But more specifically, has the prosecution proven beyond a reasonable doubt that he had those specific intents and mental states? You have heard there are general intent crimes and specific intent crimes. Murder, attempted murder, those are specific intent crimes. It's not enough just to prove that they did the act. You have to prove they had a specific intent and mental state. So what must the prosecution prove for murder? That the defendant committed an act that caused the death of another person. That is not in dispute. The crucial element is element number 2. When the defendant acted, he had a state of mind called malice aforethought. Malice aforethought can be proven in 2 ways. Express malice, that requires a specific intent to kill. Implied malice requires conscious disregard for human life. Notice the human. Intent to kill just requires an intent to kill. Implied malice requires a conscious disregard for human life. Express malice, that's an example of a specific intent. Implied malice, that is an example of a specific mental state. And the prosecution has the burden of proving both beyond a reasonable doubt. Once again, express malice is that the defendant had expressed malice if he unlawfully intended to kill. I referenced the instruction number. Implied malice. This is what the prosecution must prove for this. And once again, these are basically sub-elements. That the defendant intentionally committed the act, that the natural and probable consequences of the act were dangerous to human life and involved a high degree of probability that would result in death. But 3 and 4 are the important ones here. At the time he acted, he knew his act was dangerous to human life. Not supernatural beings, not shapeshifters, human life. And he deliberately acted with conscious disregard for human life. Attempted murder also requires a specific intent. And to prove the defendant is guilty of attempted murder, the people must prove that the defendant took at least one direct but ineffective step toward killing another person, and the defendant intended to kill. This crime requires intent to kill, or there's no crime. You can imagine there are other crimes you can be charged with. People stab people with no intent to kill. But you don't have to speculate about what other charges could have been charged because they're not here. You are given attempted murder for Ms. Guillory or no crime at all. That is the position you have been put in. You only have to decide the charges that are brought in this case, not what other charges could have been brought. And in deciding whether the prosecution has proven the specific intents and mental states, you can consider whether at the time of the charged crime the defendant, if he suffered from a mental disease, schizophrenia, you can consider that in determining whether the defendant at the time of the charged crime acted with the intent or mental state. And it also gives other examples. You can consider in defining whether a defendant made a knowingly false statement and his ability to perceive, recall, or describe. Schizophrenia is a disease that causes hallucinations, delusions, disorganized thinking. It is not a rational mind. But you heard the prosecution's arguments is all based on putting on a person with schizophrenia, expecting them to react how a healthy person would react, how a person whose mind has not been ravaged by disease. And that just goes to show the bias toward mental illness. That is somehow not a real disease. Can you imagine the prosecutor going up to someone who's been paralyzed in an accident, cannot walk? Oh, just get up and walk.
Objection.
You can do it. Everyone else can. Would they go up to someone dying from cancer and criticize them because why don't you eat? But for someone whose brain is completely broken, who has been struggling with a progressive disease for over 2 years when nobody would help him, they expect him to react rationally. When he is out walking the nights, seeing shapeshifters and supernatural beings stalking him. So, how do you prove intent? Someone may think to yourself, how do you prove what's in someone's mind? Well, you have to rely on the evidence. And there's two types of evidence. The first is direct evidence, and that can prove a fact by itself. For example, if a witness testifies, he saw it raining outside before he came to the courthouse, that's direct evidence. Circumstantial evidence does not directly prove a fact, but you can infer from it. For example, you see someone come into the courthouse, they have rain on their raincoat or water on their raincoat, you can infer it's raining outside. Now, it's possible that person could have just been in sprinklers across the street, but that's not a reasonable inference. So that's the difference between circumstantial evidence and direct evidence. And both are acceptable types of evidence, as the instructions tell you. Now, the only direct evidence you have of intent is Mr. Dominguez's testimony and his statements to Dr. Weiner and Dr. Reed. Mr. Dominguez testified he did not want to kill the shadow figures. He did not intend to kill the shadow figures. He did not believe he had killed the shadow figures. And instruction 301 will tell you the testimony of only one witness can prove any fact. And this instruction applies equally to the testimony of Mr. Dominguez. And just as the testimony of one witness can prove any fact, the testimony of only one witness can create a reasonable doubt as to whether a crime has been proven. And what did all three experts, the only experts you heard from, you actually heard from four. All four experts agreed that he had suffered from schizophrenia. Dr. Tyler, although she's certainly qualified to do so, she did not offer an opinion on this case. She was the treating psychiatrist. But they all agreed he was in a state of florid psychosis at the time of the charged offenses. He was experiencing hallucinations, delusions, and disorganized thoughts and behavior, and that these positive symptoms of schizophrenia substantially affected his thought process and perception of reality. They had every opportunity to bring in an expert to tell him these doctors got it wrong. This kid fooled everybody. He passed every malingering test because he took that introduction to psychology class. But they didn't. They didn't even get one to evaluate him. Why? You know that when you do a case, you have to spend money. If you want to do a case well, you have to spend money. And I'll be honest with you, this is probably a case where I'm going to ask for forgiveness rather than permission at the end of this trial from my boss. But what you saw from the prosecution is they tried to do this on the cheap. Oh, we couldn't send more than 5 things to DOJ. They may have to charge us for that. I want Dr. Benson to review materials, but you're not going to charge me. They don't even bring in an expert to even try to evaluate Mr. Dominguez. Because guess what? If that expert came and said, yeah, I agree he was in florid psychosis, I agree with the others, they have to give me the report. Now I have a 4th expert, and they paid for it. So they're just going to rely on the circumstantial evidence. And this instruction is very critical. Judge McGowan, the court said, no instruction is more important, but this one's going to be significant. Before you may rely on circumstantial evidence, to conclude that the defendant had the required intent or mental state, you must be convinced that the only reasonable conclusion, supported by the circumstantial evidence, is that the defendant had the required intent or mental state. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions supports a finding that the defendant did have the required intent or mental state, and another reasonable conclusion supports a finding that the defendant did not, you must conclude that the required intent or mental state was not proved by circumstantial evidence. See if I can break this down. If you say to yourself, looking at all the evidence, you know it's reasonable that he formed the intent to kill. But looking at all the evidence, it's also reasonable that he did not form the intent to kill. If there are two reasonable conclusions, the law says you must adopt the one that concludes that the intent has not been proven. This is simply another way of restating reasonable doubt. If you look at the evidence and there's two conclusions and they're both reasonable, that is not proof beyond a reasonable doubt. So what evidence does the prosecution have? The number of stabbings. 31 sharp force injuries to David Breaux, 52 sharp force injuries to Karim Abou Najm. And this is clearly relevant to intent. With someone who has a healthy mind, who is not seeing delusion, who's not having delusions, who is not having hallucinations, the fact that they stabbed someone multiple times is clear evidence that there was an intent to kill. But that's not the mind we're dealing here. We're dealing with someone whose mind was being ravaged by a disease. But listening to them, they just gloss over that. So yes, the number of the stab wounds is relevant. It is clearly relevant to intent. But why do they keep showing those to us over and over and over again? And why do they keep mentioning it over and over and over again? The prosecutor in his closing argument even said, I keep mentioning it. How many specific stab wounds did you need to see before you realized these two completely innocent men were stabbed many, many times? But why did they keep doing it? So you are likely to believe and accept all the false and misleading evidence that was presented to you and the false and misleading statements, theories, and arguments that they made to you. The prosecutor talks about a pattern. I agree there is a pattern in this case. There is a pattern of falsehoods. And that's what we're going to discuss with these following slides. The biggest one was the prosecution's denial of Mr. Dominguez's schizophrenia. The prosecutor stood up and said, oh, it's undisputed that he has schizophrenia. That was news to me. They never mentioned that in their opening statement, and based on their questioning of those doctors, arguing that he fooled them through all their tests, sure didn't seem like they were conceding that he had schizophrenia. What did they tell you in the opening statement? Now, an opening statement is not evidence, but it's supposed to be what the evidence will show. That in December 5th, Carlos Dominguez is a student at UC Davis and he is struggling. He's not doing well in school. His girlfriend broke up with him months prior. He no longer has a job. His roommates are asking for rent. And on December 5th, he has finals. That's all the struggles he had in his mind. Don't you think if they didn't dispute that he would have had schizophrenia, they would have included that? Oh, by the way, he has schizophrenia too. And he's seeing delusions. This case was based on their position that this diagnosis of schizophrenia was some sort of hoax. Prior to this closing argument, the only concession you received was in the prosecutor's questioning of Dr. Weiner. Assume that he may have some type of mental health issue. Ladies and gentlemen, I'm sure many of us at one point in our life have said, yeah, I have some type of mental health issue. I certainly have said that. This young man has schizophrenia. And the fact that they kept denying it over and over again Even when Dr. Vinson said that she has never seen this much agreement by experts across specialties, evaluations, and settings. And this was earth is flat type arguments. They just kept saying, I don't even know what they kept saying. It made no sense. And it also shows just complete lack of insight. You remember one of our first witnesses, may have been the first, was Maria Breaux. And she testified about David's life. And much of that really wasn't relevant to the decision you must make. But I didn't object because it obviously didn't seem right. And she told about David and her being raised with a mother with schizophrenia. She told about how David had to take off from his life to care for his mother with schizophrenia. And then she talked about how David, after spending time in a mental hospital, dedicated his life to compassion. And they sit up here and deny mental illness. You know, watching that 7-hour video of Mr. Dominguez with those officers, I did not think there could be any person who could demonstrate a greater lack of insight or awareness of their situation. But the prosecution sure blew him out of the water with their arguments in this case.
Overall, this is closing argument.
I've struggled with whether I should how much I should address the prosecutor's cross-examination of Drs. Tyler, Weiner, and Vinson. And I decided I'm going to leave it to one slide. It was incoherent. It was incomprehensible. It was ineffective. It was ignorant. And it was a complete waste of time. And I'm not going to waste any more time discussing that. Falsehood number 2. There was no blood found at the Hawthorne residence. You remember this one? During the opening statement, the prosecutor stood right there and he told you, when the officers ultimately search his home, they find different things of suspected blood, meaning that it's red, it's a kind of smearing, and it looks like blood. But all that is tested actually turns out not to be blood. Officers look for blood. They tried to find blood in the house, but there was no blood. Which means that Mr. Dominguez, who committed the first stabbing of David Breaux, and the second stabbing with 52 different wounds on Karim, who left Karim's bicycle with blood on the handles and the blood on the frame, because blood was dripping everywhere, managed to get home and not leave any blood anywhere lying around his home that was going to be detected later. In fact, nobody's blood was found in Mr. Dominguez's home or linked to any item of the home. Why was that theory important? Because that was their evidence that he planned this out. Clearly, if he concealed all this evidence, then he must have had this specific intent. Did you see that evidence? Well, there's two explanations. Either they did see the evidence and they just decided to tell you something false, or they didn't even look at it before they came up with their theory. In other words, they came up with their theory of this case and they didn't even have the time to look at the evidence, to read the police reports, to see if it was actually supported by the evidence. Did they look at the photos? Nope. They did not even read Alexis Torres's report. I love Alex Torres. We're going to talk about him more later. But he put it right there in his report. Now, Sergeant Vesvich reviewed it, but she didn't think that was important enough to tell them. They did not even read their own PowerPoint. Remember that PowerPoint presentation during the opening statement? They put this up there. Swab from the computer. Presumptive and confirmatory tests for blood. They didn't test it for DNA, but it was confirmed to be blood. They didn't look at the evidence. They didn't read the police reports. They didn't even read their own PowerPoint. And they come up and tell you this theory that's going to prove that he cleaned it up. It's like, I have my theory. Don't tell me anything contrary to it. Don't show me anything to it, because this is the theory I'm going for, and I'm not going to deviate. Ladies and gentlemen, if this case was not so tragic, if this was not so terribly sad, if this case was not so terribly, terribly heartbreaking, I would think I was in some sort of absurd comedy, more absurd than Animal House. And I'm trying my best to keep my sarcasm level in check, because 2 people lost their lives. 2 completely innocent people lost their lives. But this is the prosecution they get. The prosecution did not even address this in their closing argument. I was waiting for it. Okay, what is their explanation going to be? Are they going to say, you just didn't read it, sorry, there was a lot of evidence, or, yeah, we did, we just didn't tell you. They didn't even address it. Kind of reminds me of that Seinfeld episode when George quit his job and then showed up the next day and just pretended nothing had happened. That's what you have here. They gave you this huge promise. It was a complete falsehood, and they didn't even address it. Falsehood number 3. But the knife was cleaned, but only once. They swabbed, this is what they said in their opening statement. They swabbed 11 different areas of this knife looking for different DNA, and they find Karim's DNA on there, and they find Kimberlee's DNA on there, but David's DNA cannot be identified on the knife. It's only the DNA that is missing from the knife. So we're going to be able to see that at some point, after David is killed, but before Karim is killed, we have something to be removing all of that DNA, so it's not discovered. That's their theory. They're going to prove to you that he cleaned the knife. Didn't clean it after the first, the second, or third stabbings, but they're going to prove to you he cleaned this knife, and that shows their intent. Remember Heather Tomchick's testimony? When they asked her whether the absence of Mr. Breaux's blood means the knife has been cleaned, and her response is, there's a typo, so many things that could have happened with that knife afterwards versus being cleaned. How it was handled, how it was stored, what it was used for after that event. If there's not DNA, it would have gotten away somehow, but I can't say for certain it was clean. And then the court says, well, that's not really your area of expertise, is it? And she says, correct. The court asked, you just test for DNA. She said, right. And then the court said, I just want to make sure I understand if you had any training in that. And Ms. Tomchick shaking her head, no. I can't say whether it was cleaned or not. And they did not bring in another expert to tell you that. Now, ladies and gentlemen, I realize there may be people on this jury with expertise in DNA, but you've heard the judge's instruction. You cannot go back into that jury room and offer your own expert opinion, an opinion that is not tested in court, subject to cross-examination. What you can do is rely on common sense and experience in assessing this as to why Mr. Breaux's DNA was not found on that blade. What we know is they did not swab. Mr. Breaux, as you can remember, was dressed in multiple layers of clothing. There wasn't much blood at the scene. It was trapped under those multiple layers. So what you can imagine is these stab wounds, the blood is only going to be on the blade because it's going in and then coming out, and there's multiple layers of clothing. They don't swab the entire blade with a Q-tip. They only do the 11 spots where they see blood. So we don't know if David Breaux's DNA was on the portion of the DNA that was sampled, or we don't know if the DNA has been masked or just washed away by the other contributors, such as the 52 stab wounds to Mr. Abou Najm, the 2 to Ms. Guillory, or the 1 to Mr. Dominguez. That is why I asked about the proportion of the DNA. Some of you may be saying, why is he asking about proportion? This isn't relevant to the test results, and it wasn't. I was trying to show how much of the DNA was from Mr. Abou Najm, because that was the attack that was so bloody. And you can imagine that 52 knife wounds can have an effect of washing away or masking other DNA. I'm just using common sense and experience. They had an opportunity to bring in an expert. They didn't do it. Unfortunately, you cannot be your own expert in the jury room, but you can use common sense that you and all the jurors possess. Falsehood number 4. Jose and I was sleeping at the sitting log. Why was this important? Because Mr. Dominguez testified that he was going to the sitting log. That's why he was down near the area of Kimberlee Guillory. If he wasn't going to the log, if he was just going down there, then the prosecution can argue he was going down there intending to target the homeless people. So they call Mr. Anaya, who has pending criminal charges. He's given an offer of immunity. No promises. All he has to do is tell the truth. And the truth, we know, is that he was 3 blocks away with his girlfriend at the cable car wash. But by sheer coincidence, he's mistaken. And he testifies, no, I wasn't there. I was sleeping exactly where the defendant says he was that evening. And you can recall the prosecutor showed Mr. Anaya this photo, had him draw where his encampment was. We took a lot of time trying to figure out how he got into it. So the argument was going to be made. Clearly he wasn't at the sitting log because Mr. Anaya would have seen him. That was the argument. There was only one problem. There was a body camera of Mr. Anaya being 3 blocks away. And of course, the prosecution will say, well, we showed you that body camera. Well, yes, they showed it to you, because I think it's fair to assume that if they didn't, I was going to show it to you. But they may argue, no. We wanted Mr. Anaya to testify to what he saw. A person in a gray shirt running. Remember that? That's what he said on the body camera? Mr. Anaya was at the cable car wash. He is past the Davis Glass camera. Mr. Dominguez is on a bicycle. He's not running. He's wearing a black hoodie, not a gray shirt. Mr. Anaya came and he just made something up. And there's 1 or 2 reasonable conclusions. Either he is just mistaken, and by sheer coincidence, he happened to be mistaken at the exact location where Mr. Dominguez said he was. Or that Mr. Anaya knew exactly what he needed to say. You decide which one's more reasonable. Falsehood number 5. Miss Guillory saw Mr. Dominguez. Now, there's no dispute that Mr. Dominguez was the person who stabbed Miss Guillory, but her testimony is relevant to the extent it goes to intent, because she describes seeing this person attacking her. She remembers seeing his face. Remember that? And the prosecution knew this wasn't true. They knew she'd been influenced by Isaac Cheeseman's false statements. They knew from the interview that she had told them she wasn't sure if what she remembered actually happened. And they knew from her recorded statement, Detective Muscardini, which you saw, that she couldn't identify anyone. She said, I'd just be guessing. I just remember a white guy with blonde curly hair. You have her statement, Detective Muscardini. So since they knew that, why did they even ask her, can you identify, do you see the person? Because they wanted that moment in court for her to point out at Mr. Dominguez, and they got it. And it was completely false. And the sad thing is, Miss Guillory, I don't think she was lying. I think she believed it at that time. Because, in fact, I know she believed it at the time. But it wasn't true. And the fact of the matter is, she told the prosecutors in this meeting the week before that she wasn't sure if what she remembered was even accurate. And she started telling him about Isaac Cheeseman's statement to her, which she clearly knew about before she even went to the hospital because she mentioned it in the recording statement. So in her mind, the person who had stabbed her, this mental illness was making her sick because he wasn't mentally ill. He had been there 2 hours earlier scoping her out. Clearly in her mind, it was intent. The prosecution knew that was untrue for since a few days after this, but they let her believe it. But you heard the testimony from Mr. Moe. Well, we don't want to influence a witness's testimony. Mr. Moe didn't even know that wasn't true. The person who knew that wasn't true was the prosecutor. So if they're so concerned about influencing her testimony, why, when Detective Muscardini went and told her at the hospital that he made an arrest, and she asked, does he have blonde hair? Why did he tell her no? He has dark hair. Why is it okay to influence her testimony when it implicates Mr. Dominguez, but when she believes he did something that he absolutely didn't do, no, we don't want to influence her testimony anyway. More falsehoods. That Mr. Dominguez cut Mr. Chessman's tent strap. They brought that up again. You saw the tent strap. It was a bungee and then a piece of string that did not match. There was no cut tent strap, but they keep making that argument. Don't focus on the details, just remember the number of stabbings. Oh, and the tent. We have the exact same, this is what they told you in the opening statement. We have the exact same model tent in a non-ripped up form. A demonstrative that we can set up, you'll see, and they set it up. And they did an excellent job setting up that tent. They pulled those straps down as tight as they could. They got that rain flap down as tight as they could. The prosecutor did an excellent job setting up that tent. As long as he left after immediately setting up, I'd love to take him camping. But that wasn't the tent you had. And you saw that from Alex Torres saying, I thought you were going to bring in the real tent. And you saw the videos. It wasn't even the same tent. Did they think you weren't going to notice? Then we have Mr. Dominguez's use of the name John Joas with a date of birth of October 10th, 1999. That he did this to conceal his role in the stabbings. The prosecution wants to argue this proves that he knew that he did these crimes. We know Mr. Dominguez testified that he'd used that name before, a month before he had these acts, when he was just stopped for no particular reason by Central Park. And we know from Dr. Lee's testimony that people with schizophrenia do this. They give false names. They give false information. It's a disorganized mind. And we know from Ava Binda's testimony that at least 2 weeks before, he put a different name on a test. Now, we don't know that it was John Joas, but let's use reasonable inferences. And the prosecutor, in response, argues with Ms. Bindas, or Dr. Bindas, that wasn't possible someone just who was not on your wait list, came into your class, took your test, put their name on, and then poof, disappeared. That was the argument on cross-examination. It was absolute nonsense, but they did it anyway. You saw this approach to cross-examination. One approach, as I said, was just to restate the questions I asked, but try to frame it in a way that is less damaging. For example, he's asking Ms. Rocha about Mr. Dominguez. Well, he never had to come to court in a wheelchair. Since when does schizophrenia prevent a person from walking? What is that question even about? It's just asking nonsense. But it goes back to the number of stabbings. Because these crimes are so terrible, because these victims are so innocent, because this case is so heartbreaking that you won't care. And then we have the catalog. On the final day of trial, a defense attorney's Christmas dream, after they called him a liar over and over, he was telling the truth. And let's be clear, it wasn't that they just decided, you know, he does sound credible, let's see if we can find it. They called Gene Lyon, they talked about how long the catalogs were retained for, then they were this liar had said. Exactly where he said it was at, on a bike, a white male police officer, at a month before. Well, they'll say, well, he said his name was Joseph John. So, and I'm expecting them to make that argument on rebuttal. He said John Joas. His name was to conceal his role in the murder. When he told the experts, he just made that up, and he was telling the truth. This young man has been called a liar over and over again in this trial, and evidence keeps confirming that he's telling the truth. But they don't stop. Falsehood number 9. Basically everything Steve Ramos says, writes, or testifies to. You saw this, of course, is Steve Ramos's interview, his summary of what happened during that interview. I'm not going to read it again. We went over it very clearly. Where he describes what Mr. Dominguez allegedly said to him. And remember, this video was shown by the defense. If Mr. Dominguez had really said what Steve Ramos claims, they would have shown it to you. But it was just made up. They love to call Mr. Dominguez a liar, but they fail to recognize that big glass house at the Davis Police Department existed. But they love to throw rocks.
Let me stop you there. Deputy, could you bring the blinds down? Thank you, Counsel.
And the question that still hasn't been answered is why Steve Ramos, in the most important case in the history of Yolo County, or recent history, with all of this experienced law enforcement officers present, why is the only person who's been demoted, why is it he is the one to take the lead? And this is just an analogy. There was a 1989 comedy called Major League, in which Charlie Sheen plays a pitcher for the Indians called Ricky Wild Thing Vaughn. And every time he goes to get away, he gives up a towering home run. So fast forward to the end of the season, they're playing a playoff game with the Yankees. The pitcher is struggling, Clu Haywood is up to bat, and the manager comes out and says, "Get me Vaughn." And the catcher, played by Tom Berenger, said, "You want Vaughn?" The manager goes, "Yeah, I know he hasn't had the best luck, but I got a hunch he's due." And of course, Vaughn comes out, the crowd is singing Wild Thing, he pitches, he strikes Clu Haywood out in 3 straight pitches, and Indians win the pennant. But that's a movie. In reality, you don't do that. You don't put in the person who has no success. You put in the person who you're sure can do the job. Because in reality, what would have happened, Clu Haywood would probably hit another home run off him. So I'm just wondering if someone back in the Davis Police Department, when deciding who to take the lead, when they have such good law enforcement officers available, someone said, "Get me Steve Ramos. Yeah, I know he hasn't had much luck being an honest or good police officer, but I have a hunch he's due." Well, he wasn't. He gave up another towering home run. And what is sad about this is that he brought Detective Muscardini down. Detective Muscardini's question of Mr. Dominguez is certainly not a textbook for how to conduct an interrogation, but I agree with the prosecution. He is not Steve Ramos. When none of the other officers would admit that they were trying to question Mr. Dominguez without reading his Miranda rights, he did acknowledge that. He testified to that. And when Sergeant Bestpitch tried to defend Steve Ramos on the stand and say, "Oh no, that's what he believed," Detective Muscardini, no, he acknowledged that's not true. So he does have integrity. And it may have been different if he was in there by himself. It may have been different if he was partnered with someone like Derek Russell or Alex Torres, who wasn't a detective yet, but you know it would have gone much differently. But it wasn't. He was partnered with Steve Ramos. And he got partnered with an officer who was bad at his job, who was dishonest, who misrepresented, and he brought Detective Muscardini down. We don't know what would have been happened if it had been different. This is what happened. So more falsehoods. Officer Story and Gonzalez's testimony about turning off their body cameras just admit it. They knew exactly what they were doing. Well, the argument today that the stabbing of Miss Guillory was interrupted by her friends, no, it wasn't. Mr. Dominguez was gone immediately after the scream. Isaac Chessman came out naked and punched Larry Pilot in the tent. It's almost as though they're not even listening to the evidence. They keep making these arguments that the evidence shows is not true. You saw that the other day when the prosecutor goes to Mr. Dominguez, and Mr. Dominguez said, if my dad hadn't driven me home, I wouldn't have been able to get back to UC Davis. And the prosecutor says, aha, isn't the Capitol Corridor run directly from Oakland to Davis? And Mr. Dominguez says, well, I don't know, I was in Tracy. It's like they're not even listening to the evidence because they have this theory and they just have blinders on to anything that contradicts their theory. I've already mentioned that the prosecutor did not want to correct Ms. Guillory because he did not want to taint her memory. Alex Torres, all items of evidentiary value were tested. That was an example of the prosecutor just restating my questions in a way to try to make it less damning. When Alex Torres was bringing out the bloody shirt, the bloody shorts, the bloody hamper, and explaining that I recommended they be tested, but they weren't. And he said they should have been tested. And the prosecutor stands up and goes, well, sir, isn't it true that all items of evidentiary value were tested? No, it wasn't. Why are they asking that question? Oh, that he was turning off his cell phone to conceal his crimes. You have Mr. Chase's report. This was a phone that was kept dying. Yes, he powered off his phone one time at Sycamore Park. How is that relevant on a night no one was injured, no one was killed? How is that relevant? Oh, and the argument say that he looks like any other person at Safeway? I don't know what Safeway the prosecutor is shopping at. Look at that video. Look at his face. Look at how he acts in that video. That is a young man who was sick. That was a young man suffering from the symptoms of schizophrenia. So disorganized he doesn't even bring in his wallet or his money. He goes to buy food because he feels the bread is bad because the cat got into it. This is a young man who was sick. And what is sad in this case is that he'd been sick for 2 years. And no one did anything to help him. You see, when someone is injured physically, people rush to help. We saw that with Mr. Abou Najm, Dr. Massey, the neighbor. But when someone is mentally ill, people do nothing. Or just tell them you should probably need to get help. And Mr. Let me ask you something. Why does it not get to this point for other people with schizophrenia? Because there are people who have family members, when they see their son staring at a wall all Christmas break, losing weight, not talking, say, you know what, you're going to the hospital, you're not going back. Or there are the people who are homeless, so they're out in the community eye, and people see and call. Mr. Dominguez was in the middle. He had a home, he had income, and he just had that disease progress and progress and progress until he's alone, wandering the streets of Davis at night, hearing voices, believing and scared that he's being stalked by shadow figures. And I don't blame the teenagers. The teenagers who saw this, who didn't know how to handle that. but I do blame his parents. I have no doubt that Mr. Reales-Campbell loves his son, and he was proud of him. And I understand the importance of work, particularly for people in the immigrant community. But he and his wife completely failed at the most important job they ever had, and they did it over and over and over again. From the moment they abandoned their son in El Salvador to the moment they hired coyotes to smuggle him to the United States without any concern for what may happen to him. These were not people. El Salvador has problems. We all know that. But this was an upper class family. He was safe. He was with his grandmother. And they made the decision to traumatize him. And we've seen from the experts what trauma can do to a person with the genetic predisposition for schizophrenia. More falsehoods. He has anger issues because he punched a wall. Like I said, if this case wasn't so tragic and so terribly heartbreaking, I would think I was in some comedy, punching a wall. I can assure you that Mr. Reales-Dominguez is not the only person in this courtroom who, as a teenager, has punched a wall out of frustration. My father used to say, "You guys think you're really tough punching a hole in chalk. Wait till you hit a stud." This is by way of analogy. This is simply an analogy. My father had teenage boys in the home, except for a 2-year period from 1979 to 1997. And I'm sure, like many of you, your fathers or mothers, you may have had to patch a few holes. My mother's greatest story is 10 years after I graduated from high school, my father goes to paint his room and removes a picture and says, "What is there a hole in the wall?" Which my mom just decided to hang and not tell him about it. This is nonsense. This is just nonsense. And they're making this nonsensical argument in the most important case. He is possessive and jealous. Did you hear any evidence of that? He loved Kaylee. He was in love with Kaylee. But when she broke up with him, he understood. He took it well as he could have. Did he probably get, when he started to develop symptoms of schizophrenia, did maybe have gotten a little nervous that his friends may be an interest in Kaylee? Maybe. But that's a symptom of a disease. It's like the prosecution wants to argue that, yes, we're going to concede he has schizophrenia, but all these issues he has are unrelated to schizophrenia. He's angry not because of schizophrenia. That's the argument they're making. But they don't have an expert who will say that because it's not true. Financial problems. He had a timing of financial problems. He had full financial aid. Oh, and he killed because Kaylee did not want to hang out with him on April 19th. That's their theory. Remember that text message? You want to hang out? No. The next day he responds, "Ite." She broke up with him a year before. He hadn't seen her since December. He'd already sent her a few texts that she hadn't responded to, but for some reason he really wants to hang out on April 19th, so their theory is that caused him to kill. Where is this coming from? They are so desperate to avoid the conclusion that this happened because he was sick with schizophrenia and experienced delusions. They're just grasping at whatever they can find. This is my favorite. He bought the knife on December 5th during finals because he was upset about taking his first final. He did not do well that term. But go back and look at the Amazon search and his final schedule. He took one final before he purchased that knife. It was his Ed Psych final. He got a B+ in that. So he obviously didn't do too bad on that final. Yes, I know there are certain people, if they get a B+, that may cause them to go into a panic. Carlos Reales-Dominguez is not one of them. This is just stuff they keep making up. And they want you to believe it because these crimes are so terrible, because these victims are so innocent. because this case is so painful. And they believe they can tell you whatever pops in their head, whether it's supported by the evidence or not, and you'll accept it. Excuse me.
Objection.
Overruled argument.
Falsehood argument number 20, falsehood number 21. I'm eventually going to stop at some point because I could keep going with these falsehoods, but we need to get this case to you eventually. The prosecution's argument that Mr. Dominguez knew he had been terminated from UC Davis. They didn't even argue that anymore because the overwhelming evidence shows he didn't know. Remember, that was the theory? He was terminated, so he went on a killing spree. The only evidence you had is that Joyce Fernandez sent him an email on April 25th. What is the evidence he did not know? The UC Davis records. He's making appointments. He's going, you see from the Brian Chase's cell phone data, he's going to his meeting on May 2nd, a little bit late. On May 3rd, he's scheduling a new appointment for May 17th. If he's terminated from school, why is he doing this? You have this from his testimony. You have this from his statements during his 7-hour interrogation, where he repeatedly told them, no, I'm still in school. You have this from the evidence about what he said when he was in custody. So they want you to conclude that the fact that he got an email, the only reasonable conclusion is he must have, the fact that he was sent an email, the only reasonable conclusion is that he must have known he'd been terminated. I'm sure many of you have emails you have not read during this trial. They don't even argue that. That was the theory, like the no blood in the house, which they completely abandoned and they don't explain it. Falsehood number 22, the prosecution's claim that Mr. Dominguez gave intentional false information during the interview. That this shows he knew he was caught. It's clear in that video, this is a young man who was sick. He had no clue why he was there. He had no insight. You saw that when he tried to get up and walk out. But he gave his correct phone number. He gave an email that was almost correct. He gave 782 Hoffman instead of 762. Ladies and gentlemen, if you're going to give a false address, you're not going to give one that would only be a few houses down from where you actually live. He said his mother's name was Varla instead of Carla. He gave his correct high school, but he couldn't spell it correctly. He gave, again, the name John Joas, that's a typo, it was 10-10-99. The same one he used on March 28th. He gave the name of one roommate, Phil. So ask yourself, at circumstantial evidence, is this evidence of deception, of trying to conceal his identity, or is this evidence of a young man with a completely disorganized mind from a disease that he did not bring on himself, a disease he was not getting treated for? What is the most reasonable conclusion? And then we get to, it's not false, but it's completely irrelevant as to intent. The 500 cached images on his phone when he purchased, so he purchased the knife on Amazon. We all know how Amazon works. He scrolled through all these knives cached up on his phone. No evidence of him looking for knives on other dates. But the prosecution says 500 knives. It's trying to imply that he has some fascination with knives. How Detective Ramos kept trying to get him to say, oh, this knife is special to you. I'm sorry, when I learned about these cached images, I'm thinking, my gosh, I hope my phone never gets extracted, because you can imagine what people are going to find. And I'm sure some of you may have had that same feeling. Holy cow, I go to a website and everything gets uploaded on my phone? And then we have the cached images of the David Breaux Memorial Bench. They want to argue that proves he went on and saw what he did. No, he just went on to the UC Davis website to make an appointment to talk about his degree. Then we go to the knife in my hand, the poem song, which that is their evidence of intent. Mr. Dominguez doesn't remember writing it. He doesn't know what it means. He thinks it's about sex. You can see the reasons why he may believe that. Yes, it could be subject to other interpretations. But let's assume, for the sake of argument, that a year and 3 weeks before David Breaux was killed, he wrote a song about killing someone. Does that mean he had an intent to kill? One of the few breaks I had during this trial was I live in Napa and I got to go to Bottle Rock. And I saw Green Day, and they didn't play the song, but they have a song, I Want to Stab You in the Heart. Does anyone think Billy Joe Armstrong really wants to stab you in the heart? And then the next day at Bottle Rock, Ice Cube was playing. And I can list a lot of songs that he does about killing. Does anyone think Ice Cube really wants to do it? If maybe you're not into punk or rap, maybe you like country. Does anyone think Johnny Cash really wanted to shoot a man in Reno just to watch him die? Or that Willie Nelson, when he sang in The Highwayman, that many a soldier shed their lifeblood on my blade, that he was really going to stab people? This is nonsense. But that's all they have. And you saw how the prosecutor worked the knife into his opening statement. Really dramatic language. I mean, it was a good effort. But let's be honest. Oh, and the use of the words dude or him when speaking to experts. At the time, Mr. Dominguez was speaking to experts, he knew he had actually stabbed people. All the experts understood he was speaking about supernatural beings, shadow figures. None of them thought this use of the word dude or him meant anything else other than a 20-year-old or 22-year-old man explaining, now medicated, what happened. But that's what they give you. That's what they give you for proof beyond a reasonable doubt. Like I said, if this case wasn't so tragic, if it wasn't so terribly sad, if it wasn't so absolutely heartbreaking. Now, Instruction 26 tells you that if you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or if you think the witness lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. But I will submit, although this instruction applies to a witness, if the prosecution deliberately tells you over and over again things that are not true, maybe you should not consider accepting any arguments they make.
Objection, misstates the law.
Okay. Sustained, disregard that.
You have to be convinced beyond a reasonable doubt what happened. And just because the prosecution says their theory over and over again does not make it true. You did see a good example of good police work. Derek Russell, Detective Alex Torres. And if that man does not trademark the phrase, I am refreshed, I am going to brush up on my intellectual property and I will file it myself. That is a good police officer. The poor man got called back to this trial like 12 times. And he kept coming. But he did his job. He did his job thoroughly. You can expect good police work. You can expect entertaining police work from Alex Torres. And wow, how this case might have been different if Alex Torres was in that interview room. And you saw Derek Russell. He didn't play a big part, but what he did, he tried to do a good job. He tried to get the video of Mr. Siddiqui being chased, but both of them were overruled by people above their pay grade. You can do a good job. You can have the ability to do a good job. But when people who have seniority over you call the shots, sometimes you are prevented from doing a good job. So I've talked about all the falsehoods now. Now I'd like to talk about the evidence that corroborates Mr. Dominguez's testimony.
Let me stop you there. And so I know you have more to go. Let's take our afternoon break, folks. And it'll be a 15-minute break. Remember the 3-part admonition, and we'll get started at 3:15. So a couple extra minutes. Thank you, folks. Thank you, counsel.
All right, let me pull up. We have one more little section here to go. Let me just pull this up. Oh shoot, I had it. Okay, here we go. All right, so one more section to go, about 30 minutes. So I missed all of this because we were on, I was working with, on Lori. We were following Lori. So I missed all of this, so I'm really glad. Really glad that we have this, that I'm replaying it, because this is for me too. I missed all of this. All right, so this is the last section. And then I want to play, Wednesday there was a jury question. So I want to play that.
Dominguez testify about how he saw a face, half a face, which he'd never seen before in a shadow figure, and how he grew paranoid and scared, and that's when he fled. You go to People's Exhibit 1, photos 7361, you will see the face that he saw. And he told both Dr. Weiner and Dr. Ree about seeing this face. Regarding, you heard Mr. Dominguez testify how frightened and scared he was when he saw the shapeshifter on the bicycle at Sycamore Park. If he was simply a person, cold-blooded killer going to kill someone for the sport, why would he be scared? Particularly after the evidence shows that Karim was either unconscious or likely passed very early on, well before Dr. Massey got there. But what did Dr. Massey say? I thought I was chasing a scared young man. What reason would Mr. Dominguez be scared? Why would he still be there unless he was seeing something that wasn't real?
Can I pull that mic? It looks like it's pointed down. There you go.
This mic, I know I'm struggling with it.
Thank you. No, it's good. Thanks.
Dr. Massey's statements. The prosecutor focuses on Dr. Massey's use of the word man, that this person looked at him and said, "What do you want, man?" And so the prosecutor argues that means he recognized Dr. Massey was a human being. Dr. Massey gave multiple different statements about what this person said. In the 911 call, he quoted him as saying, he asked him what's going on, and he said, "Nothing, man, what are you doing?" That's Exhibit 31A. But when Officer Feng Lee arrived, he quotes him as saying, and he goes, "What's going on? Why are you bothering me? Leave me alone." No mention of man. Now the prosecutor in questioning Corporal Lee says, well, that was right at the time. He didn't have time to wash up, to reflect. But then we had Steve Ramos' body camera, and you can rely on it because the body camera, Steve Ramos' body camera is reliable. He can't alter that. And he explained to Mr. Ramos that this man said, "What do you want? Just leave me alone. What do you want?" No mention of this man. And in his testimony, he comes back and says, "No, I remember the word man. What do you want, man? Leave me alone." Dr. Massey's use of the word man. He does not use that in describing the statements to Corporal Lee. He does not use it in describing the statements to Detective Ramos. But he does use man in his own everyday speech as a filler word. You're going to hear that when he's speaking to Detective Ramos as they're walking to the park. And he says, "Are you guys okay?" And nobody responds. I'm like, "Oh man." We all have filler words we use. Detective Gioni had her did-it-to-do. Remember those? I have my ums. I don't hear myself saying them, but they're there. And some of you may have filler words, but what you're going to see is most likely is Dr. Massey, when he was testifying, he was very careful, he was very reserved. He had thought a lot about this, and it's clearly how he testified so slowly and clearly. That's probably not how he speaks in everyday speech. But you're going to hear him use man. So let's hear what he first says to Detective Feng Lee.
So he picked that up, and he said, you guys okay? Do you have a bike wreck? And then I saw him bleeding. He goes, what's going on? Why are you bothering me? Leave me alone. And he took off. And I chased him, but I realized he was on a bike. I couldn't catch him. He got away.
So no use of the word man. And that's immediately after it. That's completely consistent with someone being scared and not recognizing what it is. Now we're going to hear Steve Ramos and listen, because you'll hear him use man on his own before he describes what Mr. Dominguez allegedly said.
And you're going to be back parking on the tennis zone.
I had my iPhone light on. Okay? And nobody responded. I'm like, what is some about you? When I saw that there was a person on the ground in his backpack, I saw the assailant over him, like doing something, and then I realized it was just one bite. And then as I went up, I'm like, what's going on here, guys? You guys okay? And then the guy jumps up and says, what do you want? Just leave me alone. What do you want? I said, what about you?
If you didn't hear it, you will hear it when you watch it closer in the jury room. Once again, he does not use man when describing. And that's a really, isn't it possible he's just mistaken? If that's the only evidence they have that Mr. Dominguez knew this was not a shapeshifter, that is not proof beyond a reasonable doubt. People, and even assuming he did use the word man, people use that in everyday speech for many reasons, not necessarily to designate. People say man to women sometimes. That doesn't mean they believe they're a man. And it's just more of the nonsense the prosecution is relying on. And then what else corroborates Mr. Dominguez? That he said immediately after abandoning that bike, he turned around and ran home. They never looked at any cameras on the other side, on the same side of Sycamore Park, because they didn't even assume the fact that anyone who was just leaving a scene, anyone rationally thinking, would immediately come back. They didn't even check. And you notice Dr. Massey's camera, it stopped immediately. I bet if they had kept that camera, you may see Mr. Dominguez coming through that park shortly before Officer Fenley arrived. But they didn't even look because they just assumed no reasonable person would immediately turn around and come back if they were fleeing the scene. No mentally healthy person would do that, but he did, because he was scared and he wanted to go home, and this was the only way he knew to go home. And his testimony is corroborated by Hannah Cheney. And yes, she could not remember when she was here, but you have her recording, and she described Mr. Dominguez to a T. He looked younger. I want to say like early 20s, maybe late teens. I do remember he kind of like tannish-like skin, like Hispanic or Middle Eastern. He might have had a little bit of facial hair. That was wrong in Officer Giannoni's report, you recall, and the prosecutor went after Hannah Cheney for that. It was the prosecutor who was wrong, because he didn't even look at the transcript, he just had Officer Giannoni's report. And I remember seeing, some red in there, like maybe red in the shorts. The shorts found were not tested, but we know whose blood it was. It wasn't from David Breaux, given the multiple layers of clothing. His blood was trapped beneath his clothing. And it certainly wasn't from Miss Guillory. And given the amount of blood, it was not from Mr. Dominguez. That blood was Karim's blood. And that was the red on his shorts that Miss Cheney saw when she came across the bridge. And she says, I just remember thinking that it didn't look like a typical jogging outfit or anything. They were just running back across the bridge. But I know he was definitely turning on the bridge. That was another fact Officer Giannoni got wrong in her report, and then the prosecutor went after Miss Cheney. And Miss Cheney, she's a scientist, advanced degree, and she got nervous on cross-examination and started to admitting the same thing she never said. That's what can happen when you get aggressive cross-examination. She was telling the truth. She saw Carlos Dominguez. We have Isaac Chessman and the tissue-size hole. And there's a question that someone lied about, someone you can consider not believing. I don't think Mr. Chessman lied. And I like Mr. Chessman. He kind of sees himself as a hero. When you hear that he was the one always in front of the TV cameras, you're like, that makes sense. That makes a lot of sense. And in his mind, he believed he had chased down the stabber, and he wanted to tell everyone. He clearly told Ms. Guillory. And his testimony was not accurate. Boy, until where he described that small hole and he did a punch, and you saw me jump up, you saw me get the tissue, because until that time, everyone had been assuming that this had been a cut down that is inconsistent with Mr. Dominguez's statement that he punched. And you heard from Dr. Weiner, even when he confronted Mr. Dominguez about this, he still said, I remember a punch. And there it was, the tissue-sized hole. It was ripped further. We know Derek Russell ripped it all the way. Completely corroborated. They're writing to experts, writing a couple that are showing this fact shows that he's lying and he was telling the truth again. Where have they proved Mr. Dominguez's lies? When I asked about whether he had a prior shoplifting, he could have said, no, I never do that. Yeah, I stole a bag of chips. Could they have ever proven otherwise? He's never been arrested. It's a young man with schizophrenia taking the stand in aggressive cross-examination, asked to testify about a time when he was in a florid psychosis, when the experts are trying to tell you he's not going to remember everything. And they criticized him because he said, I don't remember having the knife, because he'd sat through a trial where people are often guessing and adding facts that they don't actually remember. When people are really telling the truth about memories, it comes out just like Mr. Dominguez. You remember one thing and then another thing. No one has memory where you have all the details. People fill them in. But Mr. Dominguez didn't do that. And the location of the two stab wounds, we don't even remember, we don't even know which buttock it was on because of the inconsistent. They didn't even prove that. They could have asked Ms. Guillory, where were you actually stabbed? But I think the most reasonable conclusion is that she was probably sitting up, that the first stab wound came down and got her in her back. She probably started to stand up and then got it in the buttock. That's the most reasonable conclusion. But it's they have to prove to you beyond a reasonable doubt. This evidence that he's down here like this, there's no evidence to support that, other than the tent that's not even the real tent. I want to talk about the surveillance. Because you have the video of the dark figure, the silhouette, running westbound on 3rd Street. And Mr. Dominguez testified he does not remember running that way. He remembers running south on L and turning west, going back toward the city line. And it's possible that could be him, that he's just remembering it wrong. He does have memories wrong. He remembers the UC Davis van coming toward him. Clearly it's not. But if you look at it, the evidence shows that's not likely Carlos Dominguez. At 11:42:16 to 11:42:19, you see that silhouette. And that's all it is, it's a silhouette. You can't make anything out of it. Running westbound on 3rd Street. But then, only 17 seconds later, Kimberlee Guillory calls 911. Then at 11:45:12, you see the UC Davis security van come into view westbound on 3rd Street. Then at 11:46, that 320 K Street video ends. 11:46, that K Street video ends. And then Derek Russell doesn't turn on his body camera until 11:51:33. So what evidence do we have about what allegedly happened in that 17 seconds? I want to show you that we're going to watch a little bit of a video from Alex Torres. Watch the distance from Alberto Osorio's tent to the corner. It's not a very far run, so.
Good. We're recording.
That's love here in Alex Torres' voice.
Exterior scene. L Street between 2nd and 3rd Street, adjacent to the Brickton PG&E yard. Case number 23-1983. Videographer, Corporal Alex Torres. May 2nd, 1983.
There's Mr. Osorio, who's in there with John Weddle. You can see the corner. That's the corner right there on 3rd. So it's not a far distance. Someone can run in it, can make it in a matter of seconds. But what do we know happened before Miss Guillory called 911? We know, and we have Alberto Osorio. Mr. Osorio came to court 3 times. First time he didn't smoke any marijuana, so they sent him home. The second time he testified, but no one explained to him, we're only asking what you saw or heard. And then the third time, when I gave him that directions, and he was very clear about only testifying to what he saw, and we realized what he testified earlier was told to him, but he was clear about what he remembers. He was in his tent with John Weddle. Where is John Weddle? And where did he go after he heard his screams? So he hears screams, he hears commotion, he does not hear anybody run by him. And his tent's right by the sidewalk. And that's the way Mr. Dominguez would have had to go if he was that person in silhouette. He gets out of his tent. He does not see anyone. He gets to Miss Guillory's tent in less than 1 minute. And now Isaac Chessman, Larry Pilot, and Christine Barrios are already out of their tent. Christine tries to call 911, but cannot do the service, so Mr. Osorio directs and watches Miss Guillory. How can all that happen in 17 seconds? Could some of the times be off? We don't know. They've testified it's all accurate, but that shadow could very well be John Weddle or someone else going to see if they can find the person who just did this to Miss Guillory. They have not proven to you that it was Mr. Dominguez. And even if it was him, and it's just because of his schizophrenia, he does not remember exactly which way he ran, you can make it back to the sitting log that way. And then we have the timeline from the Davis Glass and Ace Hardware. You see the bicyclist pass Davis Glass and turn south on 8th Street. You see at 11:45:41, you see the UC Davis security van pass Davis Glass and turn south on 8th Street. Excuse me. Then you see the time when the bicyclist turned south on 8th Street from the Ace Harbor video. And the Ace Harbor video is approximately 17 seconds ahead of the Davis Glass. So one of them, both of them can't be correct, but they're pretty close. And as after Mr. Alice Dominguez's bike turns, you see a sedan coming north. And then you see the UC Davis security van turn south. Now, Mr. Reales Dominguez says he remembers the van coming toward him, and that's what caused him to almost crash and the chain fall off. Well, that can't be correct based on the video. So there's one of two explanations. Either it was sedan that did it, and he just happened to see the security van, and that in his mind now believes it's a security van, or the fact is he may have tried to turn around and saw the security van. But once again, if he's making up a story, why not make up a story that's consistent with the evidence? Because he's telling the truth. And the evidence corroborates that over and over again. And if not from hallucinations and delusions, if he did not see shape-shifting shadow figures he was scared of, what is the motive for Carlos Reales Dominguez to want to hurt David Breaux, Karim Abou Najm, and Kimberlee Guillory? What motive would any person have to hurt those people? Based on anything you've heard. He's never met them. They never harmed him. He didn't know them. The prosecutor just wants you to believe he's such an evil person that, completely unrelated to schizophrenia, this young man who every day after school took the bus home to get his sister home from school, who went to college, wanted to be a doctor so he could help people, who even in that interview room wanted to now be a nurse to help people, because he didn't have the grades for medical school. They want you to believe that for no reason, no hallucination, he just turned into a cold-hearted killer who wanted to kill people because he was angry. That's the argument they're making. Where is the evidence of that? You know, I was struck. There's a lot of parallels in this case. David Breaux went to Stanford. He has a mother with schizophrenia. That was Carlos Reales Dominguez's dream school. You may have noticed on Karim Abou Najm's driver's license, these two young men were born in the same month, the same year, 24 days apart. Karim, no doubt, had the same dreams and aspirations Mr. Reales Dominguez did, or similar. What motive would he have for wanting to hurt these people? None. But he's had to sit here through this trial while the prosecution, not based on any evidence, calls him a cold-blooded killer. Yes, he killed two people. He injured another, and he has accepted that. But you heard Kaylee Gallardo say, that is not the person I knew. The person I met freshman year would not have done that. It was a disease. And he did not believe he was hurting people. But that's what they want to argue, that he's just a cold-blooded killer. So ask yourself, what is more reasonable, that Carlos Reales Dominguez, that you heard about, just suddenly decided to be an evil killer, or that he got sick, he started seeing things, and nobody helped him?
Sorry, I got to mute that because I don't know if that's going to cause a copyright strike or anything with that music. So I had to mute that, guys. So I'm just muting it.
Takeaway, where are you going? Takeaway, take art. Well, yeah, you know, he's oh, you better do this. You know, he's a supportive one. Oliver's a shit talker. Y'all will see in a minute. I just had to find him. He talks shit all the time. Let's see. Right, he's hella soft. Don't worry about him. But yeah, look. But yeah, this here you have Paul and Jackson. Say hello to my fans, my subscribers.
I use the subscribers.
Follow my YouTube account. But yeah, hold up. Where's Oliver? You know, this is the people I hang out with. I got right there too. Here we have Mr. Bennett, this teacher. So I don't have his class, but I wish I did. But y'all see where's Oliver? That's them all. Let's see. Oh, that's the principal. Principal right there. Oh, y'all want to say hello? And say hello to my YouTube channel. Yup. Oh, here we have Chris. Chris. Say hi to my. So I know what I'm gonna do this channel about. I'm gonna be doing gaming. I'm gonna do Fortnite and Call of Duty World at War. Please make sure to subscribe and like my videos. And I'm also gonna do challenges, 3 AM challenges, straight on challenges, stuff like that. So, my channel will be pretty lit. Make sure to subscribe and follow.
Mr. Dominguez has now been on medication for 2 years, and his positive symptoms are under control. But as he told you, as the doctor told you, he is still mentally ill. And he talked to you about the negative symptoms he still experiences, and you saw them for yourselves. He doesn't express much emotion. He told you he still has a rigid posture. He sits still for long periods of time. So that young man is gone and is never coming back. Yes, he is alive. But it is the disease that took the lives of David Breaux and Karim Abou Najm, not the Carlos Razamin you saw there. And although he does not express emotion, he told you he feels emotion. And he has to recognize that he killed 2 people, he stabbed another. And whether the fact that he didn't intend to doesn't matter. He took lives. And he has had to sit here while these prosecutions call him a liar, call him evil, over and over and over again. And yes, he doesn't express emotion, but imagine the emotion he is feeling. And they do it not based on evidence, not based on anything. So we go back to the presumption of innocence. A defendant. And the issues in this case, ladies and gentlemen, are the specific intents and mental states. Those are the elements in dispute. And unless the prosecution proves those specific intents and mental states beyond a reasonable doubt, he is entitled to an acquittal, and you must find him not guilty. So what is express malice? Go back to the circumstantial evidence. You must ask yourself, has the prosecution proven beyond a reasonable doubt that Mr. Dominguez intended to kill? If you say to yourself, based on the evidence, I think there is a reasonable possibility that he intended to kill the shadow figures. But I also believe, based on the evidence, there's a reasonable possibility he did not have the intent to kill. If both are reasonable, even if you believe one more than the other, the law says you must adopt the finding that he did not have the specific intent. And that means the presumption of innocence controls, and he is not guilty of first-degree murder, and he is not guilty of attempted murder. Those crimes require intent to kill. If they have not proven intent to kill beyond a reasonable doubt, if they have not proven intent to kill is the only reasonable conclusion you can get from the circumstantial evidence, the presumption controls, you must return a verdict of not guilty on first-degree murder and not guilty on attempted murder. And there's no lesser included of attempted murder. They decided to charge all or nothing on attempted murder for Ms. Guillory. So then we go to implied malice, which for implied malice, that's for second-degree murder. They have to prove, once again, beyond a reasonable doubt, that Mr. Dominguez
when he acted, he knew that his act was dangerous to human life, not shapeshifter life, not shadow figures, to human life, that he had that actual knowledge. And he deliberately acted with a conscious disregard for human life. And ladies and gentlemen, there's no evidence of this. Maybe you could believe he intended to kill the shapeshifters. You can find some evidence. There is no evidence, based on what you've seen, incredible evidence, that he knew he was acting with conscious disregard for human life. So once again, go back to that circumstantial evidence instruction. Is it reasonable that based on all the evidence, he did not know his act was dangerous to human life, and he did not act with conscious disregard for human life? Conscious disregard means I know something and I don't care. I'm just going to do it anyway. Then that presumption of innocence controls, and he is not guilty of second-degree murder as well. So, once there's your circumstantial evidence instruction. You're not going to need to get to this, I hope, but for first-degree murder, if you find murder for first degree, they have to prove, once again, beyond a reasonable doubt that the defendant had a specific intent to kill. For first-degree murder, you cannot have implied malice, that he carefully weighed the considerations for and against the choice. I'm not going to address this. You can look at it, because unless you convict him of murder, you don't get to this. So what happens if you find him not guilty of murder, first-degree murder and second-degree murder? He is guilty of all the general intent crimes. Because under the law, general intent crimes is not a question whether you have a specific mental state. You just have to do the act. There's no dispute, he did the acts. So what is he guilty of? For both count 1 and count 2, he is guilty of involuntary manslaughter. And for both counts, you should find true the enhancement that he used a weapon. I'm not even going to discuss the elements, because mental state is not in defense to those. Those are general intent crimes. So you can look at the instructions, but that's the verdict I'm asking you to do. Once again, not guilty on first-degree murder, not guilty on second-degree murder, not guilty on attempted murder. For count 1, I'm asking you to find him guilty of involuntary manslaughter and find the enhancement for use of a weapon true. And for count 2, I'm asking you to find him guilty of involuntary manslaughter with use of the weapon true. As I told you in my beginning, this is a case for serious adults. Adults who recognize the importance of this job. Adults who recognize the importance of following the law, even when it's difficult. Even if following the law will result in an outcome that may upset some people. It is in those difficult cases that it is so important to follow the law. And under the law, Carlos Dominguez is not guilty of murder, and he is not guilty of attempted murder. And that is the verdict I'm asking you to return. Thank you for your time. Thank you for your service over this long, long trial. And now I'm asking you to do your duty. Thank you.
Okay, thank you, Mr. Hutchinson. That was the defense closing argument, and I'm going to stand up and stretch, and then Mr. Moore can proceed with the final argument.
Thank you, Your Honor.
Off the record.
Friendly until about an hour and a half. Thank you, Your Honor. We spent about an hour and a half this afternoon hearing about 21 falsehoods. There are 2 that are missing from that list. One, that schizophrenia killed David Breaux and Karim Abou Najm. Schizophrenia did not kill them. Carlos Dominguez did. And that's a very, very dangerous argument to say that schizophrenia killed them. Because it casts a stereotype on people who have schizophrenia and makes it appear that they are always violent.
Objection, improper argument.
Good. Closing argument. The jury, if they can do with it what they want. Go ahead.
Thank you. And so there's no denying that Mr. Dominguez has schizophrenia. You heard that this morning. You've heard that through this case. The second biggest falsehood that we didn't hear is that Mr. Dominguez is not guilty of these charges of murder and attempted murder. Because he is guilty of those. Now, in closing arguments, defense's closing arguments, you heard a lot of attacks on various people. And that's fine. If you have the facts on your side, argue the facts. If you have the law on your side, argue the law. You don't have to either go after the people involved in the case. It's fine. But you remove every single one of those people that he talked about. The prosecution, Steve Ramos, Muscardini, every one of them. You know what it changes about this case? Nothing. Absolutely nothing. Because the facts stand as they are. The facts are that Carlos Dominguez stabbed them to death. David and Karim. That is what the facts are, and that is irrefutable. And so, that is what the most serious part of this case is. You don't have to like the prosecutors. You don't have to like the Davis Police Department. But you do have to like the law, and you do have to like the facts. And that is what you base your decision on. Not personal animosities, vendettas against individuals. And so when we look at the case, we look at the evidence, and you look at the experts that came in and testified, why wasn't there a fourth expert? Because all the experts rely on the same information. The same information that you have to critically evaluate. The biggest source, as I mentioned, for that information, for the expert reports, came from the defendant. A person, an individual whose credibility is at issue. And if his credibility is at issue, and you find that he had a vested outcome in this case, that he did not answer questions, or withheld evidence, or withheld responses from that, their opinion about his florid psychosis, their opinion about what he saw falls away. That is the linchpin to their conclusions. And as Dr. Weiner said, he implied in that question about how do you control for the truth, and his response is essentially, I can't. And if the experts cannot control for the truth, that brings into question the credibility of the sources. It does not bring in the question of the credibility of psychiatry or psychology, but it brings into question their opinions and what they rely on. And so if you're relying on someone with that interest, that vested interest in the outcome of the case, and you rely on someone who took the stand and says things such as, I gave a name on May 3rd, 2023 to the Davis Police Department, that was false, because I had given it before, and they had let me go, so I gave it again, in the hopes they would let me go again. That right there is a credibility issue. That right there calls into question everything the defendant said, and the defendant believes. But there's also, like the knife, another edge to that. Because if he's in this florid psychosis, and he gets stopped by the Davis Police Department, and he has the murder weapon in his bag, what are you going to do? Oh, it worked before. I'm going to do it again, and they will let me go. Work once, let's try it again. Is that florid psychosis? Or is that awareness of your state of mind, of the situation you're in? Is grabbing the bag and holding it tightly to you because you have the weapon in there florid psychosis or intellect? It's the latter. It's the latter. And he knows. And even though he took the stand and answered questions, and he was subject to no more rigorous cross-examination than any other witness in this case, both by defense and prosecution, trying to uncover the truth behind that. And the truth was coming out. Because once he was confronted with incriminating facts and incriminating evidence, this wasn't a fragmented mind. This was an individual who retreated from the things that would get him in trouble. You know what happened before, you know what happened after. But we're going to forget what happened in between. He can be schizophrenic. He is schizophrenic. But remember, you can be schizophrenic and have clarity of thought. And so, as he was testifying, subject to cross-examination, and Dr. Ree and Dr. Weiner had to come in and testify again about some of the statements that the defendant made. And in their forensic interview, he was saying the defendant said that he had the knife. In the cross-examination, that was inconsistent with what he said on cross-examination. And you use that to weigh the truth and the veracity and the credibility of his statements. And when you start looking at all the inconsistencies, all the deliberate falsehoods, it goes directly towards his credibility, and those extra reports and opinions fall away. And what you are left with is the physical evidence and circumstantial evidence of his intent and his state of mind. And so when you're going through those and you're looking at them, and his version of the interactions with the shapeshifters, and how he explains these things, the information he is providing in these forensic settings, forensic meaning there for a legal purpose, the information is very, very skewed. And so, as he's giving this evidence, or he's giving these statements to say what these interactions are, they don't make sense. The defense would have you believe, well, that's because he has a fragmented mind. No, because he can't keep the version of what events will keep him out of trouble straight. He says he goes out at night to clear his head of the voices. Voices that we only heard once actually spoke to him, and it identified David by him. And if you are going out to avoid these voices, why do you leave your cell phone? Why is it the only thing you take with you a combat and hunting knife? Ladies and gentlemen, when people leave to go to a destination, they take phones, keys, wallets, things like that. You take the things you need with you. What Mr. Dominguez needed was a combat knife. And if he's so scared of these shapeshifters that he has said he has seen underneath a desk, he's seen in his room, remember, ones he's never stabbed before, and ones that, based on his testimony, he didn't believe were real.
Objection to the state's testimony.
Sustained.
Well,
That's the jury disregard.
Disregard.
ones that he had mentioned that he had seen, but the ones that he attacks happen to be the real people. Because he knew and he understood what it was he was seeing. And so why them? Why David? Why Karim? Why Kimberlee? And yes, Mr. Dominguez is schizophrenic, but does have an issue with temper. Not just that one instance of hitting a wall that the defense mentioned. There were many more. And I'm not going to go through them because you know. You did hear evidence about his jealousy from Kaylee, about his possessiveness from Kaylee, so you do have evidence of that. So he targeted them. He had the opportunity to do so. He had the opportunity to attack them, and the evidence will show that mindset. You don't have schizophrenia attacking these individuals, these people who you can feel, you can perceive, you can touch. Now, the pattern of falsehoods with Mr. Dominguez continues between his fake names, his claims of not knowing things, his version of the interactions, the poem that he wrote. Now, the places, the artists, the rappers, the singers, the songwriters that you heard in defense closing, Johnny Cash, they didn't kill people. They sang about those things, wrote about those things. But when you write a poem and then you commit the act, that's your mindset. That's your mental state. And it brings us back to this pattern. This pattern of Mr. Dominguez going out at night with this knife, finding people in isolated, dark areas, and attacking them. Knowing very well that him is David, that dude is Karim, and you may think, well, wait a minute, those are just words. Words have meaning. The law is made up of words. And those words have significant meaning. Because we heard yesterday from Dr. Weiner and Dr. Reed, they were asked, how many times did you say shadow or shapeshifter in your report? And they testified about that. But in those instances, dude, those words were not shadow and shapeshifter. If that is what he had perceived and seen then, they would have included those words in there, but they didn't. And that's proof beyond reasonable doubt. That is proof that the information given to them, the information received by you from Mr. Dominguez was not factually accurate. And so that is why this case is not involuntary manslaughter. Because involuntary manslaughter requires criminal negligence.
Objection, not approached.
Listen, at this point, the jury has the jury instructions. We've advised them on the law. We've told them that they're going to rely on the instructions that the court gave them.
And as I said earlier,
Just a moment.
oh, sure.
I have an objection to make, but
Okay, thank you.
it states the law.
All right, you can approach. Thank you. Just a moment, folks. Off record.
And so, because of the intentional acts, you don't get to involuntary manslaughter. The deliberation, the premeditation, and the intent to kill. And so the verdicts that should be returned are that of first-degree murder. Because what this case is about is not about the falsehood of schizophrenia killing David and Karim and almost taking the life of Kimberlee. The truth is that the defendant did. And for that, he is guilty. Thank you.
Okay, thank you, counsel. That concludes the people's final argument, and that concludes the closing argument phase of this jury trial on this Friday at 4:10. And so now I'm going to read to you Calcrim 3550. And I'll remind you that I will have these instructions copied for you. Ladies and gentlemen of the jury, when you go to the jury room, the first thing you should do is choose a foreperson. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is your duty to talk with one another and to deliberate in the jury room. You should try to agree on a verdict if you can. Each of you must decide this case for yourself, but only after you have discussed the evidence with other jurors. Do not hesitate to change your mind if you become convinced that you are wrong, but do not change your mind just because other jurors disagree with you. Keep an open mind and openly exchange your thoughts and ideas about this case. Stating your opinions too strongly at the beginning or immediately announcing how you plan to vote may interfere with an open discussion. Please treat one another courteously. Your role is to be an impartial judge of the facts, not to act as an advocate for one side or the other. As I told you at the beginning of the trial, do not talk about the case or about any of the people or any subject involved in it with anyone, including but not limited to your spouse, family, friends, spiritual leaders, advisors, therapists. You must discuss the case only in the jury room and only when all jurors are present. Do not discuss your deliberations with anyone. Do not communicate using any form of social media during your deliberations. It is important that you not use the internet, not watch the media, not read the media, not follow blogs, don't use a dictionary, don't use a law book, medical book, or anything in connection with this case during your deliberations other than what I give you. During the trial, several items were received into evidence as exhibits. You may examine whatever exhibit you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin deliberations. I'll get to work on that on Monday. With the exception of exhibits that may be possibly have blood on it, if you wish to see any of those exhibits that I have not sent in, please make a request in writing. If you need to communicate with me while you are deliberating, send a note through the bailiff, signed by the foreperson, or by one or more members of the jury. To have a complete record of this trial, it is important that you not communicate with me except by written note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You should continue your deliberations while you wait for my answer. I will answer any questions in writing or orally here in open court. Do not reveal to me or anyone else how the vote stands on the question of guilt or issues in this case unless I ask you to do so. Your verdict on each count and any special finding must be unanimous. This means that to return a verdict, all of you must agree to it. Do not reach a decision by the flip of a coin or by any similar act. It is not my role to tell you what your verdict should be. Do not take anything I said or did during this trial as an indication of what I think about the facts, the witnesses, or what your verdict should be. You must reach your verdict without any consideration of punishment. You will be given verdict forms as soon as all jurors have agreed on a verdict The foreperson must date and sign the appropriate verdict forms and notify the bailiff. If you are able to reach a unanimous decision on only one or only some of the charges, fill in those verdict forms only and notify the bailiff. Return any unsigned verdict forms. I do, at this time, need to address our alternates. This jury will begin deliberating. You are still an alternate juror. The four of you are bound by all instructions about your conduct. Do not talk about this case with anyone. As indicated, not family or friends. Do not decide how you would vote if you were deliberating. Do not form or express opinions about the issues in this case unless you are substituted for one of the deliberating jurors. Before you leave, please provide the bailiff with your phone number, okay, so we can personally contact you. Those phone numbers will be destroyed at the end of the trial. It is important that during court hours, 8 a.m. to 5 p.m., that you remain within 30 minutes of the court. 30 to 45. I need to have you here in a prompt way. When we call, I need you to get in the car and come. So be reasonable. If you're needed, the jury will not be able to do anything until you get here. And as the four of you know, when I substitute you in, that means I will have rolled the dice. Any one of you may substitute in. Okay. I also indicated in an instruction to all of you that this trial has two phases. Okay? So it may be that the four of you will be back for phase 2 of this trial. All right? And so that's the instruction for the alternates. Please stick with the 3-part admonition and be ready to serve when we call. Okay? So at the end here, in just a minute, I'm going to direct the bailiff to take the 12 seated in the box to the jury room to begin. The four of you will be excused until I call you. We will be calling you, okay, to update you on the trial, to tell you what's happening, and tell you how you're needed, okay? You are not excused from jury duty until Francisco calls you. All right. Thank you. So, Mr. Clerk, at this time, I'd like you to swear in our courtroom bailiff.
You do solemnly swear that you will take this jury to some private and convenient place that you will allow no one to speak to them, nor speak to them yourself, except in front of the court, that you will return them to open court and have freedom upon a verdict, or in order to do so.
I do.
Please state your first and last name for the record and spell them down.
Mario Aguilar, M-A-R-I-O, A-G-U-I-L-A-R.
Okay, thank you. All right. So, here's what you're going to do as a practical matter. Grab your badges, all your notepads, all your personal things. The deputy will take the 12 of you to the jury room, say goodbye to our good friends, the four. Okay? And you are setting your schedule. The 12 of you are setting your schedule. You have to be diligent and you have to be reasonable and you have to let me know what your schedule is. I started these trials at 9:30 for a variety of reasons most days. Okay, the courthouse is open from 8 until 5. You must take a lunch break. The bailiff will give you that direction. You must communicate with him clearly about your schedule and so forth. He'll give you further direction on that. Okay, but you, the 12 of you, first thing you do is choose a foreperson and then set your schedule at least for the next day or two. But the schedule is on you now. All right? And thank you. It's an honor to have you here. Good luck. Thank you. The bailiff will now escort you to the jury room. Okay, off the record. Planning for the presence of the jury, we sent the jury off to begin deliberations. And I'd like to call this case Monday morning to begin planning for phase 2, at least a preliminary conversation about that. And And so why don't we do that at 9:30, since we've been calling cases at 9:30. We'll do it at 9:30. All right, and then if the court reporter is asked to read back testimony, do the parties waive any right they might have to be present for that? And we can just send the court reporter in. Mr. DeMar, agree?
Agreed.
Mr. Hutchinson?
Yes.
Right. And I will tell you, my practice is when I get a request for read back, it's to send the whole testimony in of the witness, even if they identify a subject matter. I don't have the ability to really identify where in the transcript that is, and then if it's covered in direct or cross, then I need to find it there. It's an impossible task, and I think really bad practice. So if they ask for testimony from a witness, unless they're very specific that they want direct or cross-examined, I'm going to send in the court reporter to read the whole witness back. Okay, understood?
Yes.
Yes.
All right, thanks. And now to Mr. Hutchinson, does the defendant waive his right to be present with counsel to consider any notes communicated by the jury to the judge?
Yes, sir.
Okay. All right, thank you. And then we'll send in the exhibits that have been admitted, except those qualified by the prosecution. That was a reasonable request, so we'll hold those back. Just get a list from the prosecution if you don't already have it. Okay.
And on that, I believe it was 10A, Mr. Hutchinson and I were speaking this morning. I think we're going to need assistance from the court reporter on Exhibit 10, just to make sure we have all the numbers. I think I have a good idea.
That's a good point. Well, we'll get it sorted out Monday morning. The jury's not looking at 10A anytime soon. Yeah, thank you. I'm with the prosecution. Anything else?
Just the exhibits are just all the exhibits in the brown paper bags.
Oh, that's fair. That's easy to identify. Thank you.
There's 3 defense exhibits in brown paper bags that are also have blood on them, so.
Good. Okay, we have that. Anything else for the prosecution?
Yeah.
Okay, thank you, sir. Anything for the defense?
Yes, I need to know from the prosecution whether they're going to object to Dr. Vincent testifying remotely in Sanity phase. She's in Georgia. I need to make
The sooner the better, right? I have this. We're going to be on the record Monday 9:30, but this is 3 days earlier. Let's get it now.
Sorry, I didn't. Mr. Hutchinson asked, and I had not put a lot of thought into it. I'll get an answer this weekend now.
I really need to know.
I know.
Okay.
I did a courtesy to allow them to call Dr. Reed.
Right.
I would hope they extend the same courtesy.
I'm not trying to stonewall him.
Right. Okay. So listen. The best the court can do on this matter is the party need to stipulate first, and the prosecution needs to make that decision in a timely manner. I mean, it wouldn't do any good if I said that I'm ordering you to do it by such and such, because they could just say no. Right? So he's acting in good faith. I'm strongly encouraging a stipulation, but the prosecution has to do what they have to do on diligence with that. Okay, thank you. And I think we're done then?
Yes.
Okay, all right. Thank you, everyone. Off the record.
Okay, so that was Friday, right? And they deliberated for like 15 minutes. They got a 4-person, and then that was it. So now, today's Friday. So Wednesday they had a question. I'm trying to figure out how I get rid of. Okay, I'm gonna have to do this. It's been 5 days. They should make them work through the weekend. Shirley says. Yeah. All right. So now this happened on Wednesday, and it was real quick. And because it was streamed on the website. I didn't quite get all of it, but I got a fair amount of it. I missed hold on a sec. Let me rewind. I missed. Hold on. Let me cue it up. I think I only missed like maybe 10 seconds, 10 or 20 seconds. So this was a question from the jury on Wednesday. So let's check this out. If you guys can, and that's me with my no verdict yet. That's from the feed then. All right, so this is from Wednesday. This was a jury question from Wednesday. I'll even say that. Here, let me do that. Jury question from Wednesday. Jury, so everybody knows. Jury question from Wednesday. Okay. And I'll put that over here. Oops, nope, not that, Chris. Put that up here. Oh, I guess I can do that. I'll just leave it there. All right, then I can unpin this as well. Don't need this anymore because we're no longer doing that. All right. So you guys tell me what you hear. I was something about line 600 or instruction 600. I did take notes, so I'm going to listen to my notes while we play it back. So let's check this out. Oh, and then after this, I'll play Kitty. I'll stream Kitties for a little while.
Murder requires a plan. They underlined the first two sentences of the instruction paragraph that discusses what a direct step is, one that goes beyond a plan. So then, in looking at this, any comments by the prosecution?
I think the jury needs to be referenced back to that definition, but it encompasses it's more than a plan or preparation, because they mentioned it does have to have a plan, but it's an or in the CalCrim, so it doesn't have to necessarily be a plan that's articulated. It can be other steps as well. So I think those two things need to be highlighted, and it doesn't need to be, or would be inappropriate to just reference one in isolation.
Okay, to make sure I'm understanding, you're indicating that the court should advise the jury that CalCrim 600 is an accurate statement of the law, and as to the question whether a plan is required, the instruction indicates a plan or preparation.
Correct.
Okay, all right. Mr. Hutchinson.
I disagree with the people. I don't know how the court could clarify it any more than the instruction states. I looked up the case law. This instruction is taken directly from case law. An attempted murder requires a direct but ineffective step toward killing another person, and a direct step is defined. So I asked the court simply to refer them back to instruction 600.
Right. The direct, what's the argument here as to the direct step? I mean, the direct step is thrusting a knife into the backside of the Kimberlee Guillory. That's the direct step, right? I mean, the defense claim and fight here is all about specific intent to kill a person.
Yes, but I'll be honest, I don't fully understand this question, but you never know what a jury will be discussing. So I think, but I don't know how the court could answer it beyond referring it back to 600. Element one is at least one direct but ineffective step toward killing another person, and a direct step is defined for them, and that's straight out of case law.
It is. I mean, there's a lot of cases that you can imagine the direct step. Someone's got a gun there and pulls the trigger and the gun jams. The interesting thing about attempted murder is it's an express malice crime. Requires specific intent. You can't get it through conscious disregard.
That is correct. It requires a specific intent to kill.
Right. And so, and then we gave him the instruction, which really, my summary of attempted murder is it's not divided in first and second degree, although the court looks at premeditation when it sentences. That's my understanding of it, and that's why we gave him a verdict form on, in effect, what's an enhancement. All right. I think it's frustrating sometimes, because all you can really do is turn them back. And I think I'm most comfortable with just advising them that CalCrim 600 is an accurate statement of the law of attempted murder. And I'm comfortable with that. Okay, so I appreciate that. I appreciate everyone coming here. I can give you a summary of what I understand. The readback took place yesterday and then today as requested as to the segments of the doctors. And then I think it finished. Well, they did readback all morning, and they have a little bit more of Dr. Vinson's testimony, not much, and the jury interrupted that and wanted to discuss the status of their deliberations before calling the court reporter back to finish the reading of Dr. Vinson. And so that's the status of the readback. And I don't have any indication about when or if they will call the court reporter back, but it was interrupted, and then the next thing I know is I got this note. So I'll prepare an answer right now and get it to him. Okay? Anything else?
Other than thank you for letting us be dark tomorrow. Nothing further.
Right, yes, exactly. My hope is that that we'll get a verdict and we'll announce it on, what's today, Wednesday, so we announce it on Friday, and then and I can meet with the jury and plan it. My hope is I'm given enough notice that I can get the alternates in too, and so I have them here for the reading of the verdict, and then we would start testimony with Dr. Vincent on Monday. But that depends on whether they have a verdict for me by Friday. All right, so we are dark. This case is dark tomorrow, and so it's 2:30, and I may have more news for you today. Okay, thank you.
Thank you, Your Honor.
Yeah, off the record.
All right, so you heard him there. He was expecting, or he was hoping for a verdict today. He was hoping for a verdict today. Hold on. Okay. It is. He was hoping for a verdict today, so. All right, let's. All right, let me read back my notes from that, where it was a direct step and what goes beyond the plan. So a plan required. It requires preparation. Then he refers them back to instruction 600, CalCrim, which is California crime or criminal something, CalCrim. Then they talk about a direct step is thrusting a knife into the backside of Kimberlee. You need specific intent to delete, and we gave them that instruction. The court looks at premeditated when it sentences, and that's an enhancement. He said this is frustrating, but the CalCrim 600, he says it's an accurate statement of the law, and he's comfortable with that. So he sends it back to them. Then he's talking about the status of the jury. So they were asking for a readback of Dr. Vinson, and Dr. Vinson was the forensic psychiatrist from Georgia. She's the one that they hired. She's the one that the defense hired. All the other therapists, mental health workers, psychiatrists, psychologists, they were either court appointed or they were working with Carlos in the jail when he first came in. Sarah Vinson, Vinson, Sarah Vinson, she was hired by the defense. So the jury is spending a lot of time on her readback, which is really interesting because she was hired. All right, so he said the readback was all morning. Have a little bit more of Dr. Vinson. The jury interrupted that. He wanted to know their status. There's no indication of when or if they will call the court reporter back. He's saying he hopes we'll get a verdict and we can announce it on Friday, and then we can start with Dr. Vinson on Monday. So that would be phase 2. That would be phase 2. So, yeah, instruction 600. Thank you, Shirley. That's why. Yeah, verdict today. I don't know. All right, so let's, it's 4 o'clock, it's 1 o'clock there. I guess, let's see. They have to break for lunch. He said 8 to 5 is their is what they're. The court will be open 8 to 5, right? So they're supposed to set their own schedule. So court will be open 8 to 5, and then they set their own schedule, and he says they have to take a lunch. So I don't know if that lunch is only an hour and a half. I'm not sure. So, all right. So we went through all of closing arguments, and we went through what we just heard was the jury question on Wednesday. So I'm going to take a little break and play some kitty cam. Let's play some kitty cam. Let's check in with the kitties. How are the kitties doing? Oh, there's Polly. A little kitty cam action. Yeah, let me do verdict watch. There we go. Verdict watch. Just so people know it's verdict watch. All right. All right. David, yeah, they still have time. It's California time, so it's only 1 o'clock there. Yep, Shirley, only 1 o'clock there. So they're probably at lunch. So we still have until 5, which would be 8 o'clock my time. So we'll stick around. We'll watch some kitties in the meantime. Here, I'll play some music too. Let's play some music. Why not, right? Let's play some music. All right. I'll be monitoring. I'll be floating around. I'll pop back in, but until we get any action, I'm going to just take a little bit of a break.
You talking digits? Yeah, I kill it. Mean and spit like a villain.
You got a heart like a lion. You got me messed up without even trying. I thought you meant well, but you savage as hell. Telling me things we both know you regret. That hill should have told me about her before you sucked me in. You thought we could be cool for the summer.
Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo. Aquí mi amor, somos el amor. El mundo se paró, solo esta pasión. Me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo y no me importa nada. Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo. Aquí mi amor, somos el amor. El mundo se paró, solo esta pasión.
nothing left to get back home to, so take the first bus in the station. Everywhere is nowhere to lost souls. Let's get lost by intention, where the world has protection, where the waves hit the sand. Naked bodies in the sun, scattered lips, arms and pebbles, sinking slowly as the mud at the bottom of the ocean. We're all light and emotion, drifting without a sound. Me and Mary and I walk into her room, through lonely streets at night under blood cherry moon, till we hit the ground. Lay upon a shallow part of the dreams, late in the morning, smell of coffee and of silent fiends slowly are morphing. The recollections of drowning in each other's arms. Me and Mary and I walk into her room, through those lonely streets at night under blood cherry moon, till we hit the ground. mugiendo va. Cuando el enojo aumenta, el árbol se cortará. El río fluye, nunca solo está, no solo está. El río fluye, nunca solo está. Un corazón destruido no deja de palpitar, Mi amor es franco y fiel, no tiene fronteras y no maldad. Mi amor es franco y fiel, no tiene fronteras y no maldad. El río fluye, nunca solo está, no solo está. El río fluye, nunca solo está, no
Y si tú me quieres, ven pa' aquí, te atreves. Dame esto lento, quiero sentir tu cuerpo. Volamos juntos, cuando estamos juntos. Ven pa' aquí, mi amor, hacemos el amor. El mundo se paró, solo esta pasión. Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo y no me importa nada.
Without even trying, I thought you meant well, but you savage as hell. Telling me things we both know you regret. That hill should have told me about her before you sucked me in. You thought we could be cool for the summer.
Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo. Aquí mi amor, hacemos el amor. El mundo se paró, solo esta pasión. Me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo y no me importa nada. Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo. Aquí mi amor, somos el amor.
There's nothing left to get back home to, so take the first bus in the station. Everywhere is nowhere to lost souls. Let's get lost by intention, where the world has protection, where the waves hit the sand. Naked bodies in the sun, scattered lips, arms and pebbles, sinking slowly as the mud at the bottom of the ocean. We're all light and emotion, drifting without a sound. Me and Mary and I walk into her room, through lonely streets at night under.
All right, I am going to play some testimony. I thought this might be interesting for us.
Sure.
Let's see here. While we wait. So this was the first witness.
You see Rasmus? No, he's up here.
Oh.
Check it out, Ember.
All right, witness number one.
Do solemnly swear to speak about to give and the cause not been for the court shall be the truth, the whole truth, nothing but the truth?
I do.
Thank you. Please be seated. State your first and last name for record and spell them both.
Ms. Breaux, if you could state your first and last name and then spell it for the record.
On my birth certificate, Anne Maria Breaux, ANNEMARIA, and Breaux, BREAUX, and I also go by Maria Breaux.
Okay, thank you. Mr. DeMar, direct exam.
Good afternoon, Ms. Breaux.
Good afternoon.
Ms. Breaux, if you could just tell us a little bit about yourself, who you are, who you're related to.
I live in San Francisco. I'm 56, will be 57 in December, and I make my living as a writer, marketing writer, as well as a filmmaker. Would you like to know anything beyond that?
Well, let me ask you, I mentioned who you're related to. Did you have a brother?
I did.
Who's your brother?
I have two brothers.
Do you have a brother named David?
I do.
And who's your other brother?
My other brother is Joseph Breaux.
And you know why we're here today to talk about David, correct?
I do.
So I'm going to show you two pictures, People's Exhibit 55A and 55B. All right, approach, Your Honor.
Okay.
I'm showing you People's Exhibit 55 on the top, 55A, and then 55B on the side. Do you recognize those photographs?
I do.
And who is the individual in there?
David Henry Breaux.
And are those pictures that you're familiar with?
I am.
Did you take those or did you have those at some point?
I did not take them, but I have both of them.
And is this, in life, was this a fair and accurate depiction of David?
It is.
Thank you. Ms. Breaux, could you tell us a little bit about David?
Yes, he's my so-called little brother. He was 6'2", and we grew up in the same house, same parents. He is 4 years younger than me. We both went through the same schools. We grew up in Doherty, California, in Southern California, and I left there in 1987 to attend Stanford, and he also went to Stanford 4 years after that, and went through, he studied urban studies with a focus on community development. And after that, had odd jobs. He worked as a high school teacher. He worked in a sporting goods store. He also worked with at-risk youth as a case manager in Los Angeles, and had a couple of different relationships during that time. After college, he graduated. He took kind of a longer route and graduated in 1998, after which he went to go take care of our ailing father in Doherty. Our mother had passed away in 1997. And we had a difficult upbringing and childhood with a volatile father and a mom who had schizophrenia. And after I left, David became her caretaker. I was her caretaker before that point. And so he went back home, took care of my father, who passed away in 2004. David had moved out of the house by then, and he and I started the process of renovating our family home. Over the course of 2 years, my dad passed in 2004. He had signed the house over to us. And so David and I worked together to bring it to a livable state and sold it in 2006. And then he moved to the Bay Area. I was working at Genentech at the time as a supervisor of technical writers, a technical writing team. And then he met someone who reported to me. I introduced them, and he had a very serious relationship with her, and then struggled with depression for a number of years while he was in high school, also when he came up to the Bay Area, and was suicidal for some time. But through a loving community and this relationship that he was in, but he was not able to overcome his depression, we recommended therapy for him, and he did go to therapy. Go ahead. Sure. I know this can be a long story.
Oh,
so.
Okay. About what time frame are we talking about right now where you talk about David graduated, I take that from Stanford?
Yes, he graduated from Stanford in 1998.
And then when did you and David sell the house?
We sold that in 2006.
And then the relationship that we're talking about right now, about what time frame are we in? Right?
That, I believe, started in 2005. If I'd have to check, but I believe it was in 2005.
And you were talking about with the help of the community, and I think I cut you off right there. So you were talking about with the help of the community, what happened?
So he broke up. Him and his girlfriend broke up. He moved to Oakland, and he was in a studio apartment, and he decided that he was going to pursue, according to him, he said he had exercised his body by working out, his mind by going to college, his heart by being in a relationship. So he wanted to exercise his spirit. So he spent about 1.5 years doing deep research into Western religions, Eastern religions, and philosophical thought, and looking at YouTube videos, reading books, and he came across a TED Talk by Karim Abou Najm, who's a religious scholar, British religious scholar, and she had a TED Talk on compassion and about how she was kind of calling different institutions, communities, individuals to place compassion at the core of their values and their belief system, and that spoke to David. And so he continued about his life, but he thought, I want to do something compassion related. But at the same time, he was having health issues. And one day he kind of had a blackout and ended up in he called his friend, and his friend called an ambulance, and he ended up in a psychiatric hospital in San Leandro. And while he was there, he realized he was okay, and that he would devote the rest of his life to raising awareness of compassion.
So I want to use that to ask you about, did David have a nickname that you're aware of?
Yes.
What was that?
Compassion Guy.
And do you know where or how or when he got his nickname?
On the way back from the psychiatric hospital, he called a friend, Davis, and his friend Josh said, yes, you can stay with me. David had $50 left in his bank account, and he said, I need to do something. So he came to Davis, California, and with a note, his intent was he was going to start asking people, and he had started doing this work in Oakland, but he had a notebook and a pen, and he would ask people to write their definition of compassion. And so he did that from June 3rd, 2009 until his passing, and that's how he got to be called Compassion Guy in Davis.
And so June 3rd of 2009, is that about the time frame that he came to Davis, California?
That's the time he started collecting definitions in Davis. He came in May 2009.
And did you have a chance to visit with him when he was in Davis? Did you ever get the opportunity to come up and see him do his work and interact with people?
Yes.
And can you tell us about that?
Me and my family would come up. We always knew where to find him. He was at the corner of 3rd and C. And because sometimes my memory is a little spotty, I actually met people through email threads that I didn't really know who they were until later, and I met them in person. So people from the community, some people who are probably in this courtroom right now. And David made a lot of friends, and he brought some of them to San Francisco. Since I'm a filmmaker, he would come to see my movies, and he would bring friends from Davis. And so through that, I got to know some of the people in his sphere and people who later helped him with his compassion work.
When you say he was usually located at 3rd and C, are you talking about the intersection of 3rd Street and C Street in Davis?
That's correct.
You said you always knew where to find him. When you were with him, is that sort of the area of downtown Davis that he would stay in and interact with members of the community?
That's correct.
When was the last time that you got to see David?
The last time I saw David, it was in July 2019.
Did the two of you keep regular contact in between when you were actually able to see each other?
Yes, we did.
How so?
Through either, in various means. He sometimes had a phone, sometimes didn't have a phone. It was either through phone calls, texts, Twitter messages, or Facebook messages.
But it's fair to say that during that time, you were always sort of seeing what his work was doing, keeping track of him, and just staying connected.
That's correct.
You said that he came up and he messaged a friend when he came up to Davis to stay with that friend. Was he housed or unhoused when he was in Davis?
He was technically homeless, but not on the street until, as far as I know, 2018. And until that point, he was either couch sitting, house sitting, making use of the interfaith rotating winter shelter. So was inside, and as far as I know, he wasn't outside until 2018.
And do you know, did he prefer to live outside amongst the community, or was he actively looking for stable housing? You know?
He was actively looking for stable housing after a certain point. I should also add he was for 1 year on a tour around the U.S. called the Compassion Tour. Each month someone would host him and he would give talks and had his notebook set up at an appointed bench in that city. But it wasn't until sometime during the pandemic where he actively sought to go back inside full time.
In 2023, do you know where he'd been staying?
I believe he was staying outside.
When was the last time that you and David had the opportunity to either talk or text or Twitter, just communicate in general?
On his birthday, February 26, 2023.
And on in April of 2023, April 29th, did you receive news about David?
I received news about David on the evening of April 27th, 2023.
And what was that news?
Someone from the San Francisco Medical Examiner's Office came to my door and said that David had died.
Since David's passing, have you had the opportunity to visit areas where David either frequented or a corner where there's a bench and memorial set up?
I have.
To show you 43D. Approach, Your Honor.
Okay.
Ms. Breaux, do you recognize People's 43D?
I do.
And how do you recognize that?
At the Compassion Bench.
And so you're familiar with this area?
I am.
Is that in the city of Davis and County of Guillory?
It is.
And is that picture of 43D, is that how Compassion Bench looks in honor of David?
It's covered with flowers, and yes, it is in honor of David.
And you've had the opportunity to visit that area?
I have.
Would you say, is that a fair and accurate picture of David's bench?
It is.
Thank you, Ms. Breaux. No further questions, Your Honor.
Okay, thank you, Mr. Demora. Mr. Hutchinson, cross-examination?
I do not have any questions for Ms. Breaux.
Thank you, counsel. Ms. Breaux, appreciate you coming in here and testifying. Have a great day.
Thank you, you too.
Thank you. Mr. Demora, do you have a witness you'd like?
All right. Next up, I'm going to shoot. I'm going to shoot Newton a text because he didn't reply to my other text earlier. So I just want to make sure, like you said, are they still deliberating? All right. All right. This is Karim's mom.
Good afternoon. Thank you for being here. Come on in at the podium. I appreciate your testimony today. I'm going to ask the clerk to give you the oath, and after you take the oath, I'll have you have a seat with the stand.
Okay.
Just raise your right hand. Did you solemnly swear to speak on the give and cause nothing to the court should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please be seated. Take the first and last name for the record. Spell them both.
Nadine Yahya, Nadine Yehya.
Great, thank you. Mr. DeMora.
Thank you. Good afternoon, Ms. Guillory.
Hi.
Thank you for being here. Who are you married to?
I'm married to Majdi Abou Najm.
And is Majdi Abou Najm in court today?
He is.
And do the two of you have a son together?
We do.
What's his name?
Karim Abou Najm.
And if I may approach and show you People's Exhibit 54B.
Sure.
I'm curious. You recognize that photograph?
He's my son, Karim.
And is this a photograph that you have, that you've shared with us?
Yes, it's one of many that he had for Karim.
And when was that taken?
I didn't take that photo, so I don't have the exact date, but it was taken by one of his friends, my understanding.
Thank you. And is this how Karim looked in life?
Better.
In April of 2023, how old was he?
20 and a half.
Was he a student at UC Davis?
Yes.
What was he studying?
Computer science.
Did he live with you and Majdi?
He did.
And without giving us your address, where did all of you live together?
We live on 1537 Santa Rosa Street, Davis.
As a student, how did Karim get to school?
He biked to his classes, his work, everywhere.
And did he have a green Fuji mountain bike, green and color Fuji mountain bike?
I believe he did, yeah.
Ever see him ride it?
Every time he left home when I was there, I would look at him as he left the house, yes.
Where you live, is that on the west side of Highway 113?
That's right, across the bridge.
You say across the bridge, is that the bridge that, the bike path that takes you to Sycamore Park?
Yes, true.
Did you know Karim to take that bike path to and from school or his job?
Yes, all the time.
On April 29th of 2023, did you see Karim that day?
I did.
When was the last time you saw him that day?
The last was, I around noon, I would say. I have prepared breakfast for him, and he didn't come down to eat. He was getting ready to go to a conference. So I sent him a message asking if should I remove the food or keep it for him, and that was the last message also from him. He said, yeah, to keep it, and he wrote, coming.
So he had a conference. Did he have a conference that day?
He did have. Earlier that day, April 29, he was looking for his fancy pants to wear for an occasion, so I asked him what he had. He said he had a very important presentation, and he couldn't find that pants, so he asked me to look for him for it. So that's how I knew that he had a presentation, and we didn't talk much about it, though, on that day.
When you say he was looking for his fancy pants, you're talking about like dress pants?
Yes, and I have to say it. That morning, he's like, Mom, where did you put my pants? It's like, you have it. It's like, are you sure you washed it? Yes, I did. I can't find it. Can you check my dad's? And I said, go check yourself. He said, Mom, please do. So I went, and sure enough, I misplaced his pants among his dad's clothes. And so he held his pants and said, Mom, is this my dad's size? So that was the fancy pants, blue pants that he wanted to wear, but he ended up spending some time changing and trying different clothes for the event that day.
And that was an event, and was that an award ceremony that was going to take place in the evening?
I wasn't aware that it was an award ceremony as much as a presentation with his group, and then based on their presentation, they might have been awarded based on their work. So it was a research, part of the undergraduate research conference at UC Davis. It happens every year.
And so when he left that afternoon, did he get on the bike that you had always seen him leave on?
I didn't see him when he left. I had people that day around noon. When I went to get something from the kitchen, I saw him eating, so I offered him some tea. He said he's drinking coffee, and that was the last time I saw my son alive.
And during the day, did you ever see his bike there around the house, or did you notice it was gone?
No, that night I went out with my neighbor and walked around the neighborhood, not towards Sycamore Park, towards the other side. And when I came back home, I heard sirens. And then it was then that I checked if Karim came during my absence when I went for a walk. I looked for his bike. I didn't see it in our backyard. So I started messaging him to see when he's coming back, and I specifically said, it's like, I hear lots of sirens. Are you close? Are you okay? But that was around 10 p.m. So he didn't see that message or the many messages after that I sent that night.
And did you hear, were you expecting Karim home that night?
Of course. So it's Saturday. He had an eventful day, happy day, I would say, with his friends. It's getting close to his graduation. So I knew that he would be out, but I didn't know exactly when he's going to be back. But being the kind of mother I am, when it's getting dark, I usually create a reason to check where he is indirectly by asking, like, there is food, are you coming? Or something around these lines. So that night, when it was around 10, I started hearing sirens. I got worried, but definitely I was expecting him. It's so not typical of him to stay out without letting us know.
When you were expecting him home, did you have reason to believe he would come through Sycamore Park, take the bike path back to your house?
Yes, that would be the norm, unless somebody, because if it was very late, would drop him home and then he would pick his bike the next day. But this would be the norm. He would have to cross that bridge to arrive home.
And I can't approach with people's 25 feet. Okay. looking at this map that you hear, would you be able to just draw a little arrow to where your house is on here? I can give you this pen.
Just to note, the Santa Rosa is not named, but I can recognize the street on this map. So it is here.
Okay.
So this is not Cape Cod, it's the parallel to Rio Grande.
All right. Let's put a little circle around that little dot right there.
Okay.
Thank you. Thank you, ma'am. No further questions.
Thank you, Mr. Demora. Any questions, Mr. Hudson? No question. Nadine, how do you pronounce your last name?
Yahya?
Yahia. Ms. Yahia, thank you for your testimony.
Thank you.
Thank you. Okay, ladies and gentlemen of the jury, we are at our after.
Alrighty then. Just heard from Newton. Jury didn't come in today. Jury did not come in today. They took a 4-day weekend. So the jury did not come in today. They took a 4-day weekend. So that's the jury did not come in today. They took a 4-day weekend. They were off yesterday, and apparently they were off today. So, yep. What the heck? So that was a fun exercise, right? Well, I had not seen the closing argument, so all in all, I guess that wasn't a total waste. Plus we got, wait, hold on. We got little Rafa. Look at little bean boy over there. Well, Pants cleans herself. So, I don't know. I don't know what to tell you. I think at this point, we're not going to stream Verdict Watch. We're going to go on to another trial, and when they have a verdict, we'll cover it. We'll play it. It may not be live. Maybe we'll try and catch it that day, but probably not going to do this again. So, yeah. In all fairness, California's popping off near civic centers. That could very well be why they. Yeah, you're right. They could have decided that. That's a good point. Didn't even think about that. That's a good point. Before we get too upset at them, that is a good point. There's a lot of unrest going on right now in California, so that's a good point. That's a valid point. That's a valid point. So the jury may not felt safe. They may have not felt safe, and they may have said, hey, you know what? Let's just take off until Monday. Then there's that. So that's not the news I was thinking we were getting. Psychosaurus, yeah. Well, I don't want to say we waited for zilch. We got kitties, right? Yep, Kathy, you got kitties. Nomad, you're mad. Let's go riot. Let's go storm the Capitol. Let's go storm the courthouse. I mean, come on, man. All you can do is just chuckle. But in all fairness, hey, I was able to watch the closing arguments, which I had not seen, so I was happy to do that. And Capri Law and Widespread Panic took notes, which were great. But there's nothing that, it doesn't match actually watching and seeing it. So I was happy. I was happy that I saw closing arguments. I was glad I saw that. And I showed you guys from Wednesday the jury question, because we didn't see that because Lori was going on. So I was glad that we got that in the can, as they say. So yeah, that's it. Unrest is about 8 hours south. I know. Well, I don't know. Maybe, I don't know. Better safe than sorry. Most of our local governments are opting for a 4-day weekend. All right. We had some lovely together time. That's true. Yeah, all right. Let's look at it. You napped, got front room vacuumed and mopped. So it was productive. And the recaps, yeah. All right. So there we go. But also there's pretty much always a protest in UC Davis, so the jurors would be used to it. Right? Something good comes out of most things. That's true. Yes, we had time to spend. We had time to spend with each other. So anyway, all right, 6 o'clock. I don't know what to do with myself. We've been going since till like midnight all this week with recaps with Joe and all that stuff. I don't know what to do with myself. It's Friday at 6 o'clock. Woo, what do I do? Oh, that's right. I can go have some wine with my wife. So I shall go do that. Have a great evening, you guys. Thank you so much for joining us. Thank you to Aaron, and thank you to our mods. You guys are a great crew. Chat, love always hanging out with you guys. Thank you so much for spending some time with us, even though ultimately we didn't get... See, if I hadn't told you guys, I could have just said, yep, jury went home for the evening. I could have told you guys that. So, and then we would all be... nobody would know any different. But anyway... With that being said, have a great weekend. We're off this weekend. We're going to chill. We got to figure out what we're going to watch next week. There's a trial that started this week that I think I want to pick up on, and we are going to keep an eye on Carlos, because if they do come to a verdict and then they jump into phase 2, we will cover that. So we have some decisions to make. Aaron and I have some decisions to make as to what trial we're going to cover. So that being said, have a great evening. Have a great weekend, and we will see you guys Monday. Regardless, we'll figure out something. We'll stream something. Not quite sure what yet. Not Verdict Watch. I'm done with Verdict Watch. We'll stream something else. All right. See you guys. Have a good one.